the order date, my lord, 4/1/2023, my lord. Similar cases pending, my lord. It may be take with.
Yes. I think the petition was.
Second issue is the context of the presentation.
But is not there as per succeed.
Now 156.3. 156.3. But at this stage, I am appearing for response number 1 to 6. So 2 to 6.
2 to 6.
2 to 6.
Yes, so we'll issue notice because of any judgments?
Yes,
Which,
madam.
which one? Just give just citation.
Sudhir Bhaskar of Tambe, madam.
Huh?
Sudhir Bhaskar of Tambe, madam. Then 16/6 SCC 2 page 277, madam.
Sudhir Varsar of Tambe.
Yes, madam.
2016 6 SCC.
Yes, madam.
There is a subsequent judgment.
Maybe in my favor, madam.
Okay, right. But Sudhir, this Sudhir's case is on a different footing. That is with regard to change of investigating officer during the investigation.
But it is in Sakiba, so detailed discussion has been given, madam.
Slightly different. Anyway.
Yes.
Right. Heard Mr.
Yes, Board of Madam.
S. Bar Thakur, learned counsel for the review petitioner. Review appellant. Review petitioner.
Yes.
Review petitioner who submits that the order dated 4/1/2023 passed in WPC number 7301/2018 should be reviewed. In view of the judgment of the apex court in the case of Sudhir Bhaskara Rao Tambe versus Hemant Yashwant Dhage and others reported in 2016 6 SCC 227, wherein it has followed the judgment of the apex court in the case of Sakiri Vasu versus State of UP, reported in 2008 2 SCC 409. In the above two cases, it has been held that if a person has a grievance that his FIR has not been registered by the police, his first remedy is to approach the SP of police, SP under section 154(3) CRPC or other officer referred to in section 36 CRPC. If despite approaching the SP or the officer referred to in section 36, his grievance still persists, then he can approach a magistrate under section 156(3) CRPC instead of rushing to the High Court by way of a writ petition or a petition under section 482 CRPC. Further, he has a further remedy of filing a criminal complaint under section 200 CRPC. That's your case. Issue notice.
For 227.
Huh?
For respondent number opposite party.
Issue notice returnable in 4 months, in 4 weeks. Mr.
I'm Dina.
Dina, accept notice on behalf of
227.
respondents number 227.
Keep along.
Petitioner takes steps for service of notice upon the respondent number
1 minute.
1 by a registered post with AG within 2 days.
Yes, ma'am.
List the matter after 4 weeks. Or should we give a date? No need. We give a date. Today is what date? 21. This is the matter on 3 April, 3rd April.
But the direction maybe may not stay made for timing. Madam.
Huh?
There's a direction may not- that maybe stay made in 4123 order. There's a direction may to
Okay,
register
right.
FI, madam. In page
Yeah,
35.
in the interim, the direction for registering an FIR given in the impugned order dated 4/1/23 shall remain state till the next returnable.
Oblige.
Yeah, please, your Lordship. I'm appearing for the item number 12. Lordship, due to some person difficulties.
No. There are only two matters here.
Item 2. Only 2 minutes.
There is second DP.
It's okay. It's okay. You can come again.
Yes.
Lordship, this I criminal second time file for seeking to bail, my lord. Because Lordship, appellant, here is petitioner in jail for 10 months, 12 days, my lord.
Earlier application was rejected and this is a new application.
But earlier, my lord, this plea was not taken.
Huh?
Whether this plea was not taken, whether penetration is there, but
Whether-
under prosecution, my lord, in the PW, my lord, prosecution witness, nowhere it appears whether she was penetrated.
Whether she was,
Sexually penetrated. Sexual penetration is the ingredient, my lord, so far
Not
section 6 is concerned.
well,
lord,
this
my lord,
is under
section-
6 POXO Act.
Yes,
Foxo Act.
under 6 POXO Act.
What is this? What is that
punished.
statement?
But punishment, my lord, under section 6 of POXO Act, but 6 is not attracted in this case. So far, the
Not
evidence is
entitled?
concerned. 6 is not attracted.
Let me file an objection with regard to this point also regarding this whether six
No,
is
no.
attracted or not.
You see, why do you say that? What do you mean? Not attracted? Why is it not attracted?
But so far, my lord, evidence is concerned, PW. Nowhere it reveals whether sexually penetrated. That is not there.
Not required.
No, not.
But
Even if there is a 1 millimeter entry of a finger also, even touch is enough. You don't need penetration per se, full penetration per se. You know, the hymen doesn't need to be,
Torn or
ruptured.
not. Hmm.
It can be intact also. That is not the issue. Where is the case? Now you have got to, you see, probably, I think, let us see the evidence. Why should we wait for WO? I don't understand.
No, true.
Why should we wait for the earlier WO? You are re-agitating the same issue.
But here, my lord,
Let
so
us see
far,
the evidence.
so far medical, my lord, so far medical report is concerned, PW9, here it clearly reflected that after microscopic examination, even though
Also put it in the, that's all. There's no case. Mr. Council, come to page 24.
24. I think.
24. Please read page 24, from the sixth line. The victim examined as PW1.
page 24 in my IA, my lord.
Yes.
Here, my lord, paragraph 18.
Starts with victim.
That's it.
The victim, the sixth line from
The top,
page para 18.
para 18, 6 line. The victim examined as PW1
On
had
had
clearly
clearly
stated.
stated that the accused on the day of incident came and on the pretext of fishing took her and her brother to the bank of Becky River and thereafter asking her brother to cut grass, took her to the bushes nearby and then removed her pant and inserted his penis into her nose. This is but a wrong judgment. This thing is not appear in the evidence.
No, let us see her evidence.
Lodge.
Let us see her PW1.
In
PW1.
evidence nowhere penis word not appear. PW1.
Let us see her statement aside.
Yes. 161, may I come to the page 38, my lord, for one recorded statement of 164.
Oh, go to her statement. Okay.
Yes, you come again in page 9 of the paper book. Have you got the paper book with you?
Paper book page.
Page 9.
Page 9.
Come to page 9.
Lordship.
Come to taken on camera, you have got in bold, then 1, 2,
The
3,
accused
4,
also
5,
removed.
6,
Hmm.
seventh line.
Yes,
Then accused also removed.
removed his pant and.
What
so
more
and
do you
so.
want?
Even in the cross, it is not demolished.
Yes.
Lodge.
But it is contradicted, my lord, so far 164 is concerned.
164.
Not,
You see,
my lord,
you see, if there is a contradiction between 164, had that been put confronted, has the PW number 1 been confronted with that statement made under 164? There's no confrontation. So you have not been able to discredit the PW number 1. Correct.
my lord, this one citation is there, my lord,
Huh?
in the cross part of PW1,
Yes.
that it is not a fact that I deposed false evidence, that my brother was
It is not a
engaged
fact
by
that-
accused
where?
to cut grass.
Ah.
Now, my lord,
You see,
question is, my lord, entire fact appeared.
You see, this is a
Is
suggestion.
not,
This is not a confrontation.
trustworthy.
Huh?
Is not trustworthy because 3 villages there.
We will see that
During hearing.
during the hearing of the main case.
But so far, my lord, 164 cannot be overtaken, my lord. 164, so far evidence of PW was concerned, is not really relevant. So far, 164 is concerned, not identical. My lord. My
Well,
lord,
160,
my lord, my submission, 164, my lord, saying that question of my lord, penny is not appear, my lord. He is saying that hand.
Mr. Counsel, can you listen? Was 164 exhibited?
Huh, exhibit 1.
Exhibited by whom?
Why?
From the prosecution side. Yes.
By whom? By the person who took down the 164.
But you cannot show this evidence. My lord. 164 is very valuable. My
Yes.
lord. We can make it contradictory when it appear in the evidence of his prosecutors. And we have to take the stand. So far 164, what she stated.
Huh?
What she stated.
Let us see
164.
where is that, where has it been exhibited?
The judgment, you have to come to again judgment. My lord. Judgment.
PW number 1 has exhibited it.
The victim herself.
Victim herself.
This exhibit 1 is my 164.
Exhibit 1 is the 164 statement. Or it is, but here no finish is there.
Anyway,
Speak to the.
I think you see, whether the 164 statement should have been exhibited by the victim.
Actually, it should be exhibited by magistrate who takes it, but magistrate, I think, is not examined.
I'm not examined at all, no way. And in any event, we don't find any reason.
It's not a case that 164, she did not say anything. She said, not in so many particulars, but that will be seen in hearing. That can be seen. But as far as prima facie case, it is established
Yes, yes,
for 389.
yes, right. Heard Mr. K. Bhuyan, learned counsel for the applicant. Also heard Ms. S. Jahan, additional PP. This application for the applicant has filed this application for suspension of the sentence and release of the applicant on bail under section 389 CRPC for the second time.
Yes.
The basic submission made by the counsel for the applicant for suspending the sentence and releasing the applicant on bail is that the evidence of the victim does not prove that the applicant had caused any penetrative sexual assault on the victim girl. Next paragraph. Ms. S. Jahan, the additional PP on the other hand submits that this court had by the order dated 35/22 passed in IA Criminal 230/22 rejected the petitioner's application for bail and as such, and as there was no new development with regard to the facts in the case as had been recorded earlier, the application should be rejected. Full stop. We have heard the learned counsels for the party. Full stop. This court in its order dated 28/7/22 passed in IA Criminal 230/2020 had stated at para 7 as follows. We do not apparently see any major contradiction or inconsistency in the statements made by the victim girl under section 164 CRPC as well as before the trial court. On perusing the evidence of the victim girl and the statements made by her under section 164 CRPC, we do not find any ground to come to a different conclusion today. First of further, if there were any inconsistency in the statement made by the victim girl under section 164 CRPC, The victim should have been confronted with such inconsistent statement, comma, if any. So the same not being done, comma. We do not find the ground taken by the learned counsel for the applicant to be sustainable, that there are inconsistencies in the statement made by the victim girl during the evidence and in a statement under section 164 CRPC. Accordingly, the application is rejected. However, we would like to add that the observations made today should not affect the merits of the case at the time of final hearing of the case.
Lordship, paper book already received, my lord.
Huh?
Paper book already received, so may.
Well, in the main case, you're right.
Lordship.
Mr. K. Buyan, learned counsel for the appellant, and Ms. S. Jahan, additional PP, submit that they have received the paper book. Accordingly, with this matter for hearing in usual course.
Actually, I was supposed to tell your lordship,
Yes,
but then I
you-
forgot.
So we have
And there is a
been,
bar, so that.
there's
we
a bar
copy
in the act.
the act, Yes.
For 18.
No, there should not be live stream.
Live stream, not
Actually,
live stream.
absolutely live stream.
So we cannot do that.
Yes, that I tender my apology, I should have said.
So I think you should keep that in mind.
Lordship.
So my lord, here again back to this custody of. So my lord, just to refresh my memory,
You can refresh yours. What about refreshing ours?
my lord, I can only speak on my behalf, my lord.
Yes, yes.
To
yes.
refresh my memory, my lord.
Your basic case is that Calcutta High Court judgment
And the Supreme Court.
and the
judgment.
Supreme Court judgment.
And today I'll clarify that, my lord, this power is in the statute itself.
Is in the statute.
It's in the statute. Now, my lord, if I have understood the arguments of the other side correctly, in two lines, the argument of the other side is that there is no essential distinction between 451 and 457, save and except if the property is produced before the court, then it is 451, and if it is not produced, then it is 457.
No, but 451 will only be applicable at the time of inquiry and trial.
No, my lord, the basic thrust of the argument, I'll be stand corrected. The basic thrust of the argument by the other side is that 451 and 457 for invoking both the, either of these two sections, the condition precedent is there has to be a pending inquiry or trial.
Correct.
The condition precedent is there has to be a pending inquiry or
Inquiry or
trial.
trial.
Now, once it is produced during that stage, then 451. If it is not
Not
produced, then
produced,
457.
457. Correct.
That is the main thrust of their argument. my lord.
Agreed.
And to, and my lord, we had also made deliberation on the fact that why the legislature would use a redundant sentence or a superfluous words in 457 that not produced during inquiry or trial. If the legislature had the intention to bring into its ambit the stage of investigation under 457, then why should the legislature use a redundant phrase? That was basically, my lord, what had followed from your lordship, but that was something which was bothering the court as well as the deliberation on the last occasion. Now, my lord, I have given, my lord, what I'll try to do is that I'll try to read both 451 and 457, juxtaposing it in a same page of paper. That is precisely what I have given today, my lord. I have given one piece. This is no law, no Supreme Court judgment. Simply, I have typed out 451 and 457 in a single piece of paper. So that, my lord, this juxtaposition becomes easy.
Before you have already typed it out.
But that not in a single page, both the
This
provisions.
is the same, in the single page I've typed it out.
Oh,
No, what I'm saying is that before you typed it out, I typed it out.
oh, yes. Because I thought that would be a wise way of dealing with it. Now, my lord,
Anyway, so we'll, since you have done the hard work, we'll look at your type.
yes, my lord.
Yes.
Now, my lord, 451. When any property is produced before any criminal court during inquiry or trial, the court may make such order as it thinks fit for the proper custody of such property pending the conclusion of inquiry or trial.
Just a minute.
We have missed
No,
that
no, just
phrase,
a
my
minute.
lord.
No, it doesn't say pending.
451, my lord.
It says during. Please.
450,
It says during, not pending. 451.
451. Someone, my lord, I asked my.
And it doesn't say conclusion. It says during any
My
inquiry.
lord,
or
my lord,
trial.
that is 457, my lord.
No,
Just-
this is your paper. I've got it.
451, yes, my lord. When any property is produced before any criminal court during inquiry or trial, the court may make such order as it thinks fit for the proper custody of such property pending the conclusion of inquiry or trial.
Now pending, now pending. Okay,
Yes.
Yes.
That is pending the inquiry. That is precisely what I've.
No. You see the.
My lord, if your lordship sees my 451 the way I have typed, I have
No, no.
highlighted that word.
Okay. When any property is produced before any trial, the court may make things fit. Pending the conclusion. Yes, okay,
So,
Yes.
my lord, this is
Correct.
correctly typed out, my lord.
correct.
I thought my chamber might have probably, so it is correctly typed out. During is on the first line. During appears in the first line,
Yes,
but in the third line it appears pending the conclusion of inquiry or trial. So my lord, the point which I am trying to bring home is that when any property is produced before any criminal court during any inquiry or trial, the court may make such order as it thinks fit for the proper custody of such property pending the conclusion of the inquiry or trial. There is a very important phrase which is consciously missing in 457. And if the property is subject, I leave this, subject to nature and
but
decay.
451 says,
Yes,
when it is produced before any criminal court during any inquiry or trial.
yes,
So inquiry or trial is a precondition?
absolutely.
Yes.
Absolutely.
Then,
So I'm trying to show the distinction between 451. As far as 451 is concerned, my lord, unambiguously the statute says pendency of inquiry or trial is condition precedent. That's what I understand.
yes,
It is a condition precedent. There is no
Correct.
escape from the.
Correct,
There is no
correct.
room for any other interpretation.
correct.
It simply says quote during an inquiry or trial.
Correct.
Now, the point is that the projection was given that the only difference between 451 and 457 is it is not produced in 457.
And one is produced.
One is produced. Now, if that be the legislative intent, then my lord, 457 would have been couched in the language of 451. With one stroke of pen, the legislature would have said that whenever the seizure of property by any police is reported, then if 457 would have been couched into the language of 451, then it would have been that when any seized property is not produced before any criminal court during inquiry or trial. When any seized property is not produced before a magistrate during an inquiry or trial. Why would the legislature use the phrase in 457? The first opening phrase of 457, my lord, will kindly see that relates to which stage in a criminal case? That relates to the stage of investigation. The first sentence of 457 is, whenever the seizure of a property by any police officer is reported to a magistrate under the provision of this code. I take a pause here. Now, this stage refers to which stage, my lord? This stage refers to the stage of investigation.
It refers to 102.
Absolutely. 102 subsection 2. Because there is a mandate under 102 subsection. So this 102 is which stage? It is the stage of investigation. So 457 starts with a phrase which has a direct nexus with the stage of investigation. Had the legislative intent been that only difference is production and non-production, 457 would have been exactly couched in the language of 451. Legislature would not use their own argument that legislature will not use a superfluous words. Legislature will not use redundant words. So the main purpose of, now my lord, I was deliberating on this subject since last 2-3 days, my lord. I was only on one point was striking me was that why the legislature has not used the word investigation. That would have been the last nail in the coffin if the legislature would have used the word investigation. Now, my lord, that brought me to one very interesting judgment of the Honorable Apex Court, my lord. My lord, Section 4 of the CRPC for a while. Section 4.
Yes.
My lord, trial of offences under the Indian Penal Code and other laws. All offences under the Indian Penal Code shall be, now my lord, these are the words, investigated, inquired into, tried and otherwise dealt with. So my lord, investigation, trial, inquiry, all these three words are used, and then there is a residuary phrase, and otherwise dealt with, meaning thereby, my lord, that there is stages in a criminal case which is neither an investigation, nor a trial, nor an inquiry. Now, what could be that stage, my lord? That brings me to a judgment of full bench judgment of 1964. I'll give this judgment, my lord, 1964, which says that suppose a police officer gets an information, cryptic information under some suspicious circumstance, the police officer will make a preliminary inquiry regarding the veracity. 1964 Supreme Court is saying. Again, the Constitution. Now, that stage of preliminary inquiry is not an investigation. No, why? It is not an investigation. Because Supreme Court says what essentially investigation means is to collect evidence. That the process of collecting evidence by the police or by person authorized by magistrate, the process of collecting evidence, quote unquote, is the operative line. Now, this preliminary inquiry is a stage which is neither an inquiry, nor a trial, nor an investigation. Now, why this has relevance with 457? The nexus between this and 457. 457 is has a very wide canvas. It takes into account custody, giving custody of property not only during investigation, but also during all such stages. Therefore, they have not reduced it to mere investigation. Whenever it is reported to a magistrate, be it at the stage of preliminary inquiry, be it at the stage of investigation, be it at the stage of inquiry and trial, even during inquiry and trial, if it is not produced, then 457 can be invoked. 457 takes into it ambits all situations, save and except the situation contemplated under 451, that is when it is produced during an inquiry or trial. Therefore, my lord, now I read again, I come to that single page, my lord, where I have typed out 457. Now your lordship will see, and that is precisely why in 457, this phrase is missing, pending the conclusion of the inquiry or trial. There is no such phrase in 457. Whenever the seizure of a property by any police officer is reported to a magistrate under the provision of this code. Now, my lord, kindly a pause here. Let us put this, let us bring an analogy of a case, my lord. Now, my lord, a truck is apprehended in commission of some offense, maybe narcotics. Narcotics I'll not say because they have confiscation proceedings. Maybe my lord, kidnapping. A vehicle is produced. That vehicle is
What?
kidnapping.
Huh?
Kidnapping.
Okay. Then
Now, my lord, that vehicle is produced before the magistrate. Produced before the magistrate during investigation. It is produced before the magistrate, and such property is not produced before a criminal court during inquiry or trial. Correct. Because that property is not produced during inquiry or trial. That property is produced during investigation. That property is not produced. And such property is not produced. I'm verbatim, I'm quoting from 457. and such property is not produced before a criminal court during inquiry or trial. Meaning thereby that if such property is produced during inquiry or trial,
Look, you're just reiterating what the division bench of the Calcutta High Court is saying over and over again. You're trying to hammer that submission of yours into our heads. Try to reason it out.
absolutely, my
You
lord.
cannot bulldoze it.
No, I'm sorry, my lord. If that impression I've given, I'm sorry for that. My lord, what I'm trying to say is that the word 450, because the Calcutta High Court does not speak of these two aspects of 451 and 457. That 451, Calcutta High Court gives a reason that this refers to a stage of investigation.
Yes.
That
It says that it is a stage of investigation.
stage of
and-
investigation.
And not the stage of inquiry. or
just
trial. Now, what we are saying is a different thing altogether. It's slightly different, isn't it? What you're trying to say is slightly different.
me.
Yes.
But what I am saying, I'm coming to Calcutta High Court in its reasoning is absolutely, in my understanding, my lord, the
Correct.
reasoning given by the Honorable Division Bench of the Calcutta High Court is correct, which is followed by the Orissa High Court and some other high courts also. Now, what I'm saying, in addition to that, further, my lord, if we see, because this is a conscious deletion of this line, pending the conclusion of inquiry or trial, which appears in 451 and 457. Now, my lord, that before going to that Calcutta High Court, this preliminary inquiry, why I have submitted about preliminary inquiry is because 457 also takes into its ambit stages which are not stages beyond investigation as well, which are preliminary inquiry, stages of preliminary inquiry, stages of inquiry and trial when it is not produced, even then it is covered by 457. Now, my lord, that Supreme Court judgment of 1978, an argument was made from the would-be counsel for the state has made a submission that judgment of 1978 is sub silentio on the point. It is silent on the point of whether 457 can be invoked during investigation or not. My lord, in my humble understanding, there is no silent, rather that is very loud. 1978, what happened in that 1978 judgment, I have read it again. My lord will kindly come. In that judgment, the honorable court below has held, the way the argument is advanced in this court, the court below held that the court has no power during investigation.
No, it has given a decision that it can be done.
It can be done.
It can be done. However, without giving reasons for the same.
My lord, probably
Yeah,
the Supreme Court was of the view that this is something expressly clear, so why should we go into reasoning?
So it has not, just for us, for our understanding, we thought that maybe it should be done, but anyway, so according to prima facie, what it appears is that Supreme Court has said it can be done under 457 during investigation, but there has not been a real discussion on it. There's no the basis for coming to such a finding has not been stated, I think.
In fact, my lord, in that 1978 judgment, the last paragraph your lordship will see, there is a positive direction given to the court below to exercise jurisdiction under 451. So it cannot be sub silentio. Sub silentio is one passing remark somewhere without, my lord, 3 times the learned 1978, that is page 52 of the compilation. 3 times the Honorable Supreme Court has used the word 457, 457. If
under 457,
Under-
not 451, 457.
457, I said 457. My lord will see the page 52.
No, we have got that. We have got
The
that.
third line.
That's all.
The third, while we reverse the decision that the court,
Where is that full bench judgment you were saying? 1964, something you were saying?
1964, my lord. I have two pages. Should I mark that?
Doesn't matter. If you
Ah,
mark
para
it,
to
it's
koi nahi,
easier for us to find out. Where.
Absolutely. Para 22. This is a full bench, three judge bench. Para 22. 1, 2, 3, 4. The last page. 1, 2, 3, 4, 5, 6, 7, 8, 9. the 14th line, para 22, merely making some preliminary inquiries upon receipt of information from an anonymous source of doubtful reliability for checking up the correctness of the information does not amount to collection of evidence and cannot be regarded as investigation. Now, this is again reiterated in a recent judgment where the Supreme Court, that is the constitutional bench judgment, 5-judge bench judgment, where the Supreme Court have said that preliminary inquiry is must in certain cases. 2014, my lord.
So what you're trying to say is that this property can be seized during preliminary investigation also,
Because there is the only
preliminary inquiry also.
also, because it only says the moment it is produced before the magistrate and not produced.
So your basic case is that the words such property is not produced before a criminal court during an inquiry or trial merely refers to a stage of investigation. That's all. That's just a basic case.
Absolutely. And
Ah.
as far as, because the council have also, the worthy council have also relied on certain rules of construction, I'll not go into all those, while a literal rule of construction on all those. I'll just show one paragraph as to how CRPC has to be construed. The rule of interpretation straight in relation to CRPC. This is the judgment which I have given, a recent 2013 judgment, paragraph 39. How CRPC has to be interpreted, it relates to that, not to those Income Tax Act and other statutes, my lord. Para 39. It is true, probably the second last page, para 39.
Yes.
It is true that penal status must be strictly construed. There are, however, cases where the court has, having regard to the nature of the crime involved, refused to adopt any narrow and pedantic literal and lexical construction of penal status. I skip this, see such and such, such and such, such and such. In this case, looking to the legislative intent, we have harmoniously construed the provision of chapter such and such so as to strike a balance between the right of the complainant and the right of the accused. Besides, this is important. Besides, we must bear in mind that chapter such and such is a part of the Code of Criminal Procedure, which is a procedural law, and it is well settled that procedural laws must be liberally construed to serve as handmaid of justice and not as its mistress. Liberally construed, man. This is that. Now, Lord, as far as the suggestion which came up that read petitions, that read petitions can be filed. Read petitions or 482. I'll briefly deal with read petition and for that there is an alternative remedy under 220. My lord, I was just trying to conceptualize what would be the prayer in a read petition if the remedy is ventilated to read petition. Issue mandamus directing the police to release the PAN card of the petitioner. Issue mandamus directing the police to release the Aadhaar card of the petitioner. Issue mandamus for release bicycle, cross light.
What about 482?
My lord, 482 is an inherent power of the High Court, where if there is no other provision under the Code of Criminal. Now, 482 will deprive an entire lot of population, my lord, who are stationed nearby judicial magistrate courts or where there is judicial magistrate courts in the vicinity. Then for Trustlight and for PAN card and Aadhaar card, if they have to come to the High Court, my lord, under invoking the inherent power of the High Court, my lord, probably, my lord, that would not be a very happy state of affairs for the citizen of this country, my lord. For a PAN card, for an Aadhaar card, for a Trustlight, for a bicycle, no, you come to High Court. Today morning, my lord, though it is the man who sweeps my chamber, my lord, he informed me that he was drunk and driving caught and his motorcycle is there in the Lotus Hill police station. Then I told him, engage me 482 High Court. Probably he's getting a salary of 7,000, 5,000, 6,000 rupees salary he's getting. For him to engage a lawyer in the High Court to invoke its inherent jurisdiction to get his motorcycle, which he used to attend his duty, probably, my lord, that part your lordship will consider, my lord. That is my humble submission. Rest, my lord, I have already shown. And as far as, yes, I'm just touching upon the submissions which is made by me. I'm not making anything of my own. Today, something new. He has also said that the old act 523, in the old act 523, the word and not produced during inquiry or trial is missing under the old act. My lord, under the old act, the word investigation is also missing.
So at any stage.
So at any stage, the word investigation is. The new code only try to strike a distinction between 451 and 453, and therefore they have inserted this word, which is also apparent from the fact that the law commission report, which a worthy council have relied, the law commission report, even I have gone through the law commission report, only 2 lines of that law commission report. Only 2 lines of this law commission report, my lord. On the basis of this 43rd law commission report, my lord, this 523 was amended and 457 came in, was replaced. My lord, in fact, I have marked it because after marking, I got it xerox from the book, my lord. It would therefore be better if section 523(1), that is the old provision of 457, generally referred to all cases where the seizure of property by the police officer is reported to a magistrate, and not only to seizure under 51 and 550. 51 is seizure while searching and arrested, while during search of a person arrested, if any seizure. So don't confine it to only to that section 51 or 550, but generally to all cases.
And 550 is?
And 550, my lord, 550 is 550.
Power of seizure by police.
Power of seizure by police. Acha. The old act 550 is power of seizure by police.
No power to grant custody.
550. I have in fact marked 550 also. 550. So, my lord, power of police to seize property suspected to be stolen. Power of police to seize property suspected to be stolen. That is the old CRPC. So generally the law commission says don't confine it to 51 and 550 in all cases. Therefore, my lord, and my lord, I have not come across a single judgment of the Supreme.
How does this have any relevance to your case?
My lord, they have made an argument.
I cited it to indicate that
Yes.
under the earlier code 550, police had power to seize only.
Yes.
Now under 120, 1023, they have power to release custody also, give custody also, which was not available under the earlier code.
Under 550.
550. Only seizure was permissible. Now seizure, reporting and custody by police. This custody part has been newly inserted under the new code.
My lord, custody part was in fact there in the old code as well under 523. 523 deals with procedure by police, the seizure of any property, the seizure by any police.
523 is the old
Old act.
old section for this 457.
Yes.
Now, if 523 provides that the court can during investigation release,
The word investigation is not used even in 523.
is it?
Yes.
520 says.
523, my lord, will see
Magistrate
the
can
old
grant-
act of 523.
Magistrate can grant custody at any, it is silent, upon production before a magistrate, magistrate can grant custody. That includes investigation, inquiry and trial.
553 says the seizure by any police officer under of property taken under 51 or alleged or suspected to have been stolen or found under circumstances which create suspicion of the commissioner shall be forthwith report to a magistrate who shall make such order as he thinks fit respecting the disposal of the property. So the power to give custody was there under the old act also.
At any stage.
Under the old act it was there.
It was there. Under the new act also it is there. The only change under the new act is and not produced during inquiry or trial. That is the addition. And not produced during inquiry or trial is the addition. So this addition is made just to strike a distinction between 451 and 450, 7, not to restrict the meaning. Not to restrict it, but to restrict. I have not come across, my lord, any judgment of the Supreme Court in contrast to the judgment of AIR 1978, which says that it is not permissible to give custody during investigation. We are going into the theories of interpretation and the rules of construction and everything, my lord. But my lord, there is no judgment of the Honorable Supreme Court. I'll be stand corrected if I come across any such judgment. This is my lord, a fair submission. In my limited research, I have not come across. Again, I tell my lord with all humility, I'll be stand corrected if any such judgment comes to my notice. There is no judgment which says that custody of a seized property cannot be given during investigation by a magistrate. There is no such judgment, my lord. No Supreme Court. Rather, there is a judgment on the judgment otherwise. 1978 judgment. We are only, my lord, we are going into a deeper research of what word used. Well, one single judgment would have clarified the issue. There is a judgment otherwise, where the court have not only reversed the observation by the learned court below that you cannot give it during investigation, not only reversed, but given a positive direction that you pass order under 457.
But no reasons have
No
been
reasons. my
forthcoming
lord.
there.
Probably
That's
the Honorable Supreme Court was of the view that this is something very apparent, very ostensible, so probably reasons may not be required to, and that was by His Lordship Justice Krishna Iyer, my lord.
all. Anything, that's all?
Well, only one thing from my
Yes,
side.
yes.
Well. 451 and 457 again for a moment, madam. 451 says, my lord, when any property is produced before any criminal court during inquiry and trial, the court may make such order as it thinks fit for the proper custody. First word is, my lord, custody will be
Yes.
considered. First is considered as custody pending conclusion of the inquiry or trial. Then, my lord, if the property is subject to speedy and natural decay, or if it is otherwise expedient to do so, the court may, after recording such evidence, as it thinks fit, order it to be sold or otherwise disposed of. So first consideration is for custody. Second, if it is, my lord, speedy, subject to speedy or
So
natural
there
decay,
is, there is no
Then-
dispute with regard to
then the
451.
question of the disposal will come. Unlike this, my lord, in 457, my lord, will see, whenever the seizure of property to any police officer is reported to a magistrate or under the provisions of this code, and such property is not produced before criminal court during an inquiry trial, the magistrate may make such order as he thinks fit respecting the disposal of such property. Now it is only, first it starts with disposal. Unlike 451, it is custody, then question of disposal will come. Disposal of such property or the delivery of such property to the person entitled to the possession. It nowhere indicates, my lord, custody. It indicates delivery to the person of such property to the person entitled to the possession. So, meaning thereby, my lord, that is why the word say such property is not produced before trial court, criminal court during inquiry and trial, because it is not subject to any, it is property is not related to any commission of offense, or it may not be used as a piece of evidence in trial. That is why it is not required to produce before the court. That is why
I didn't get it.
what I feel, my lord, the word used that it is not produced before the criminal court during inquiry and trial leads to only one conclusion, that the property under consideration in 457 is not relatable to the commission of offense, and those is, my lord, not relatable to the commission of offense, and it is no way required. It is not required for as a piece of evidence in the trial, my lord. That is why it has to be disposed of first, or then custody will be given, my lord, because it is not relatable to the offense, though, but it was seized. That is why it says, and such property is not produced before criminal court during inquiry and trial, the magistrate may make such order as he thinks fit respecting the disposal of such property. Unlike 451, it is custody initially, because, my lord, that is relatable to the offense that is produced before the court. Or the delivery of such property to the person entitled to the possession thereof. Word used is delivery, not custody. So it is conclusive. 457, either disposal or delivery, that those are conclusive. But in respect of custody, my lord, it is interim custody. Unless it is, my lord, disposed of for being subject natural and the word speedy and natural decay. So the properties in 451 and properties in 457, there is a difference. 451 properties is relatable to the offense, will be used as a piece of evidence. That's why custody is granted. Or if it is subject to natural decay, it will be disposed of. Here, my lord, property is not relatable to the offense, though it was seized. That is why property is to be first disposed of, or it is to delivery of possession.
Delivered.
Word use is not custody here. Word use is delivery. Because it's not relatable to the offense, it will not be used as a piece of evidence. It is not connected, though it was seized. And next, my concluding point will be, my lord, as I have already indicated, my lord, under the earlier code, there was a power to the magistrate upon production of property, the magistrate can grant custody, dispose of the property. Meaning thereby, my lord, from the stage of production, reporting, at any stage, investigation, inquiry, trial, magistrate can grant custody. That has been consciously, my lord, changed under the new code, thereby incorporating the stages of inquiry and trial. If we now, my lord, allow 451, 457 petition at the stage of investigation, it will amount to inserting the word investigation. That's all, my lord. I have prepared a written argument and a compilation of judgments, my lord. It's being readied, my lord, within 5 minutes.
Compilation already so
No,
thick.
my lord, will ignore all
Why
my,
not such a thick?
my lord, will ignore all my judgments, my lord, that I have given as a loose copy, my lord. I have given a compilation along with index and a written argument. That I will produce, my lord. Within 5 minutes, it will be ready, my lord.
Your submissions quite plausible. Only thing is that the Supreme Court judgment is this.
That's why, my lord, I'm taking help of that judgment, my lord. It's sub silentio. It has not dealt with specifically with the
But how
issue.
are we going to say that to the Supreme Court? Do we have that
There-
authority?
There are two judgments, my lord. Two says, one says sub silentio, one says, my lord, adding, cannot add additional words. And this 78 judgment, my lord. If my lord is accepting 78, then my lord is not accepting the other judgment. So my lord, both will have
Which other judgment?
the judgment that I relied on that day, my lord, regarding construction, my lord.
Rules of construction is saying.
Regarding construction.
When the Supreme Court has interpreted some provision of the law, might not have given reasons for it, but when it has made a decision on it, can we say that the wrong or
We're not saying wrong, my lord. We're saying on the precise
he has
issue.
not gone into the
My lord, as in the present case, there was no issue framed or adjudicated before the Honorable Supreme Court that whether custody can be granted at the stage of investigation under 451 and 450. That was not an issue, my lord. And even not raised by the state also.
My lord, in my understanding of that 1978 judgment, that was an issue. That is precisely why,
I think that was precisely an issue.
yes, that was precisely an issue because 78 judgment, if your lordship visits again, will say that the Supreme Court has reversed the judgment of the court below, which says that it has no authority to give Jimma during investigation. That was precisely the issue in 1978.
Okay, anyway, I think.
That's
I'm
all,
deeply
my lord.
obliged, my lord. We have done our part, my lord.
Any more argument will be, my lord, reiteration,
Yes, if required, we can always fix it
my lord.
To be spoken.
to be spoken. Since you all have given us already such a thick list of judgments,
My lord will ignore all these judgments given by me, my lord. I will produce a
how
compilation.
can I ignore?
No, no,
I've already.
Ignore, my lord, the copies, not the
No,
judgments.
no, no.
Copies, my lord will ignore. I'm giving as compilation. my
I
lord.
hope
That
you're, I hope you're not adding. a
I will
few
not
more,
add, my lord. Nothing
huh?
is added, my lord. That's all, but my lord, in a chronological way, my lord, with index, my lord, I have prepared, so that will be all from my side, my lord, including the arguments. my lord.
Anybody else? Nobody else. Heard Mr. P. Goswami, another additional agent. Also heard Mr. Do we put that senior counsel's name? Is it required? Whose name?
He is appearing in item number 2, I suppose. no?
Mr. What
Five
are the senior counsel? All those names? Who are they? Who had appeared?
My lord, Ziaul Z. Kamar,
Mr. Z. Kamar, senior counsel, assisted
PJ
by
Saigal.
Mr.
NH Borbuya.
Huh?
NH Borbuya.
N.H. Barbuya.
my lord, different councils are appearing in different number. I'll give a list, my lord. PJ Saikya is appearing, the
Okay,
senior
also
council.
heard Mr. P.J. Saikya, another senior counsel appearing for
Item number 3 and 4, madam.
assisted by Mr.
AK Gupta, madam.
A.K. Gupta for 3 and 4, huh?
Yes, ma'am.
And I'm for this
Mr.
item number 1. Item not 1, প্রথম to কিমান number? প্রথম to 1 নাকি? Moria, that Moria case.
M. Biswas
Yes, I am this one.
for
Item 1.
item 1, yeah, for item 1. Item 1, then Mr. Z. Kamar was for which item?
5-6, Lord.
5-6. And Mr. PJ Phukan was for,
PJ Saikia.
PJ Saikia was for
3 and 4.
3 and 4.
Yes, ma'am.
And anybody else? No, that's all.
That's it.
Item 8 for one of the, but we are the same from
And উকিলৰ নামটো কি?
8 order for item number 8.
A. Dwara. Anybody else? 7?
7
Who
to
is for
cut, 7 to cut. 7 to cut.
Yes, madam.
Yes, for my yes.
Some A Sharma, my lord, will give his name.
Yeah, A.
A
Sharma.
Sharma is
For,
shown in
for,
the-
no, for item 8, huh? Right, hearing concluded, judgment reserved.
I'm deeply obliged.
Deeply obliged.
I can feel for a
Huh?
lordship. I can feel for a lordship.
Yes,
I guess senior counsel Jack Kamar is coming, so he has some.
he wants to say something.
Yes, sir.
Where is he?
Please come. I'm sorry.
Yes, yes.
I also have got nothing much to say, but what happened, my lord, in the meantime, during this intervening period, my lord, I could scan some good judgments, my lord.
Okay,
Probably it will be a matchup. I have given in a booklet form, my lord. So recently, directly on this point, my lord, but in a different act, Kerala High Court has propounded judgment relying upon the Supreme Court, my lord. So if your lordship will turn to page A and B, my lord, I have given those citations.
page 8.
A and B. First page, my lord. A and B is the citation along with the name of the party, which
Okay,
court
yes, yes,
decided,
Yes.
and what are the paragraph, and what are the serial page numbers, my lord.
yes, okay.
So first, I would like to take your lordship to this. Shanil, my lord, page B, serial number 10, my lord. And your lordship will kindly go to page 59 straightway, my lord.
Page 59.
Yes, my lord, the relevant port. Before that, it starts with page 54, my lord. This relates to a case, my lord, under the NDPSA case was registered, my lord.
Yes,
My lord, in a case raised under NDPSA, whether conveyance, that is vehicles and all,
correct.
can be taken into custody or not. But here a fact happened this way, my lord, a friend borrowed a friend's vehicle.
Whether it's a public property,
Yes,
public place,
yes, my lord. In a public place, my lord.
whether it's a public place.
Yes, my lord. That
So Supreme Court has said it's not a public place.
absolutely. That is one aspect. And the second aspect, my lord, that he has taken the car to smoke some marijuana. So
But
why?
But Delhi High Court has said that it is a public place.
Yes, sir. Correct.
Correct.
I'm obliged, my lord.
No, so where do you want to, what do you want to show?
My
me?
lord, I would like to take your lordship to, I've given the para number and the page number because it's a big para, my lord. And that para is, my lord, 2, my lord. Para 2 starts earlier, my lord, but I am coming to the relevant to cut short of my argument. Para 2 starts from page 57. Shall I read the backdrop, my lord?
Yes,
But the basic backdrop is directly at page 59 of para 2.
yes,
The down para, my lord.
yes,
The introduction of section 52A and the above direction given rise to the question whether the special code, that is the NDPS code, my lord, or the magistrate code can order interim release of the vehicle seized in connection with NDPS crimes by exercising the powers under section 451 or 457 of the CRPC. a division bench of this court, that is Shah Jahan versus Inspector of Excise and others, 2019, 5 KAC 421, answered the question to a limited extent by holding that the statutory provisions in the NDPS Act denude the magistrate of their power to consider a claim under section 451. So likewise, my lord, now the prevailing situation is there. So that has fallen for consideration before the learned single bench of Kerala High Court, my lord. Then coming to 65, my lord, now. So this Honorable Kerala High Court, just presided by Justice Arun, my lord, at page 8, he has to refer to Sunderbhai Ambala Desai's case, my lord. It is an irreversible fact that the exponential increase in crimes under the NDPS Act has resulted in innumerable vehicles being seized. In this context, the decision of Sunderbhai Ambalal Desai versus State of Gujarat assumes relevant. Therein, referring to section 451 and 457, the Apex Court made the following observation that is already placed before your lordship, my lord. Then we'll come straightway to page 70, my lord. 70, para 11, inner page 26. Although in Shah Jahan,
70?
Inner page 26, running page 70, my lord.
Yes.
That is para 11 of the judgment, inner page 26 and running page 70, my lord. Although in Shah Jahan, this court held that the magistrate to be denuded of the power to grant interim custody under section 457 CRPC, that decision is impliedly reversed by the Supreme Court in Sainaba versus State of Kerala 2020 70 KSC Iman. To summarize, in Sainaba versus State of Kerala and other, a learned single judge of this court held that the special court is not empowered to exercise jurisdiction under section 451 to release a vehicle involved in the offense under the NDPS.
Just a minute. One thing is that Shah Jahan's cases is
Yeah, earlier it was Shah Jahan hold the field in Kerala High Court, my lord. That no interim custody can be given under 451. So now it was carried forward to Supreme Court, my lord. Supreme Court impliedly overruled that side now case.
Okay.
That I have also annexed that Supreme Court judgment, my lord.
But we are on the issue of 457.
Yeah, both, whether custody can be given under 451 or 457, this judgment deals with it, my lord. I'm just reading another two paras, your lordship will get it clear.
Yeah.
So now the Supreme Court intervenes in this Shah Jahan case, my lord, and impliedly overrules that. And that your lordship will find at page 71. That order was reversed by the Honorable Supreme Court in Sainab versus State of Kerala, being contextually relevant. Paragraph 5 to 8 of the judgment is extracted herein under. It has been opined by the High Court that the court is not empowered to exercise the jurisdiction under 451 of the Code of Procedure to release the vehicle involved under the NDPS Act in interim custody. Originally, what was hold, my lord? Then Supreme Court came, my lord. The appellant has argued inter alia that as per section 36C, read with section 51 of the NDPS Act, Criminal Procedure Code would be applicable for proceeding by a special court under NDPS, and section 451 has an inbuilt provision to impose any specific condition of the appellant while releasing the vehicle. The appellant is undoubtedly the registered owner of the vehicle, but had not participated in the offense as alleged by the prosecution, nor had knowledge of the alleged transaction. Learned counsel seeks to rely in the judgment of this court in Sunderbhai Ambala Desai's case, that is such, opining that it is of no use to keep such seized vehicle in police station for a long period, and it is open to the magistrate to pass appropriate order immediately by taking a bond and a guarantee as well as security for return of the said vehicle if required at any point of time. On hearing the learned counsel for party and in the conceptions of the fact and circumstances of the case and the legal provision referred aforesaid, we are of the view that this is an appropriate case for release of the vehicle on terms of the condition to be determined by the special court. I'll take your lordship to the full judgment of Supreme Court also. Then come a careful reading.
How do we know that this is there in the investigation stage?
Oh, my lord, it's in the very beginning, my lord. Your lordship will come, my lord, one by one. A careful reading of the above paragraph makes it clear that the appeal was allowed and the direction to release the vehicle after taking note of legal provision, namely section 36 read with 51 of the NDPS and section 451 CRPC. As such, there is an implied reversal of the dictum in Shah Jahan's case by virtue of Article 141 of the Constitution of India. I also take note of the judgment in Pradeep B versus District Disposal, wherein a division bench headed by the Chief Justice expressed the opinion that Shah Jahan requests reconsideration and directed a full bench to be constituted. Having found the jurisdictional courts to having the power to grant interim custody, the ancillary question is whether such power is to be exercised under 451 or 457. That is what your lordship was asking of the CRPC. Section 451 will be applicable when a property which includes seized vehicle is produced before a criminal court during inquiry and or trial. As regards conveyance seized in connection with offense under the NDPS Act, section 52A only provides for preparation of inventory containing details of the conveyance relevant for his identification and the making of an application to the magistrate for certifying the correctness of the inventory. The seized vehicle were not produced before the magistrate, upon which alone an order of interim custody under 451 can be issued. On the other hand, the power under 457 can be exercised with respect to a property which is not produced before the court, but the seizure of which is reported. The above discussion leads me to the conclusion that the jurisdictional court have the power to grant interim custody under section 457 CRPC, irrespective of the procedure for disposal stipulated in section 52A of the Act. I refrain from delving into the question whether the seized vehicle could be termed as a conveyance or not, my lord. That is one aspect. Now, if your lordship will see the Supreme Court judgment, my lord. Page 80,
But
my
this
lord.
is very unclear.
My lord. No, my, it is there, my lord. This is during investigation, my lord. All this happened, my lord. The Sagan and all, my lord. Because there, my lord, the court said it cannot be granted during investigation, so you must approach the drug disposal committee, my lord. Drug disposal committee, my lord, constituted under section 52A regarding the vehicles, my lord. Because it is interim custody period is going on, my lord. It's not the final disposal, my lord. Because there are confiscation proceeding also. In spite of that, my lord, under 457, the vehicles were released during investigation for the convenience of the person, my lord. Because sometimes the vehicle are taken at request, my lord, and somebody misuses it. So for that, whether the registered owner should suffer, my lord. Now page 80, my lord. Shall we come back, my lord?
Yes.
But shall we come back, my lord? Shall we come back?
No, where is it specifically? How do we know that this is during the
Yes, my
investigation
lord.
stage?
Yeah, I'll show it, my lord. That's why I'm saying, shall we come back, my your lordships? Rising.
Oh, yes. Oh, yes.
That's why I said. Impliedly, it goes like way. If we'll see the Supreme Court judgment, my lord, which starts at page 80, my lord. That Shah Jahan case was impliedly overruled, my lord.
Yes.
Well, I read for your lordship, kind convenient. Leave granted, we have heard the learned counsel for the party. The appellant alleged that she is the registered owner of a Maruti Suzuki car and the vehicle was involved in crime number 74 of 2022 at Manjari PS for offense punishable under 20 and 29 of the NDPS Act. The incident occurred on 31/22, wherein accused number 1 telephonically asked the appellant's son, that is accused number 3, to come to Tirur railway station with car to pick up and drop the accused number 1 in his house. While they were so returning from Tirur railway station, the police searched the vehicle and found 4.200 kg of ganja from a bag of the accused number 1 and accordingly registered the crime. An application was filed by the appellant seeking release of the car. The special court, however, dismissed the application and the endeavor of the appellant before the High Court also did not succeed, as criminal miscase number 2371 of 22 was dismissed on 19/5/22, which had been assailed before us. It has been opined by the High Court that the court is not empowered to exercise jurisdiction under 451 of the CRPC to release a vehicle involved under the NDPS Act in interim custody. My lord, as your lordship is aware, my lord, that this custody is of two types, my lord, final custody and interim custody. So till the disposal of the case, my lord, when a Jimma is given, custody is given, is always an interim custody, my lord, with condition to produce it before the court as and when required. And thereafter, the finality of the case,
This
my
is
lord.
again under 451.
Yes, my lord. That 451 is
This is
coming to be.
451. 451, so there is no dispute.
Yes. No, but the thing is that, my lord, whether during investigation or at the end of the, at the beginning of the trial, my lord, petition lies, because that is your lordship is looking for, my lord. So whether pending investigation, no charge sheet has been filed, during that period, whether custody can be given or not.
Under
That is the
457.
question. Yes, absolutely. That is what.
But then the Supreme
That
Court.
word is not here, but relying on the earlier Shahjahan case, my lord, this judgment, sign up judgment has been passed, my lord, at page 80, my lord. Sign up. Regarding the interim custody are always given, my lord, as experience says, my lord, that is during, not during the trial, before trial, my lord, during investigation. It is always the interim custody is given for the duration, my lord, with the condition to produce the same.
No, 451 is basically after the inquiry.
Yes, ma'am, that is.
That is only after the inquiry.
Yeah.
So this is only with regard to 451. It doesn't speak of 457 at all.
Not at all, my lord. No, only the Kerala High Court says, my lord.
It has got no relevance to the issue at hand.
Exactly, my lord, it may be. No, Kerala High Court clearly says at page 75, in the result, the criminal miscase and read petition, except read petition such are disposed of, permitting the petitioner to submit application under section 457, seeking interim custody of the vehicle. That your lordship will find at page 75 of the judgment.
Interim custody.
Interim custody, no permanent custody is given, my lord. It is just a jimmadar that I agree to produce it as and when the court will direct. Because sometimes it is two types of properties are involved, directly implicating the accused with the crime, the property is involved. Say, my lord, that the pistol is required, my lord, but that has been used to kill a person. He will never get the custody because of the fact, my lord, now that this is a crime property, my lord. But if, my lord, certain registered vehicle, he was traveling from there, he shoot it and the vehicle was also seized, then why should the vehicle be kept? That is on merit. My lord, the registered owner should be given the custody pending investigation, my lord. That is my respectful submission, my lord. Now, I have got other catena of judgments from the Honorable High Courts, my lord, wherein this point has been very elaborately dealt with, my lord. I'll just take out the relevant, my lord. Within this intervening period, certain new judgments I could find from various High Court. One is also from our Guwahati High Court, 1984, way back, my lord.
Which page?
I'll take one by one probably, my lord. Guwahati High Court is at page 43, running page. That is para 13, my lord.
Yes.
Yes, my lord. On balancing competing claims, the court would have to take an overall view of the matter because question of right to possess would imply determination of ownership which arises only under section 452 and 457 and not under 451. The court is obligated under section 452 and 457 to deliver possession of the property to a person entitled to possession thereof, while in a case under 451, the court considers the entire facts and circumstances of the case and particularly the nature of the property only to determine the person to whom could be entrusted the interim custody thereof. Thus, when the property is an animal, its habits, behavior, well-being must be taken into consideration. Indeed, not the legal owner, but the person who established that it was under his care and possession of quite a long time, and there has been nothing to show that he was not kindly disposed of towards it. It must be held in such cases to be the best entitled to its interim custody. In doing so, the court will be
There
fulfilling.
is nothing with regard to whether it's during investigation stage or not.
No, my lord, here it was a revisional jurisdiction exercise. If your lordship will turn to
No,
page
whatever
one.
it may be, whatever the divisional access power or whatever power. When was the
My lord, if your
custody
lordship
or
will kindly
property
look
given?
into the opening para, my lord, probably it will come up, my lord. The forensic fight in this case is for interim custody of an elephant. OP number 2 has lodged the Azahar at Hailakandi PS on 3/1/84, and an elephant named Joymala, which belonged to him, had been forcefully removed by some person by threatening the Mahout while it was walking at Maturi Ghat. The police raised a case under 384 IPC against 4 persons in the course of the investigation, seized the elephant in question on 5/1/84 from the possession of the petitioner. On the application of the petitioner praying for his custody, learned magistrate passed an order on the body of the petition, directing the officer in charge of Hailakandi police station to give the elephant in his zimma. Next day, the informant filed a petition in the court of the learned SDCM Hailakandi, submitting that the ex parte order passed on 5/1/84 by the Munsif magistrate without hearing he was liable to be vacated and that had the said elephant should be given in his custody. The judicial investigation which followed upon the application and the order passed thereon confirmed in the revision by the learned sessions as is the bone of contention in the present case. So it was during investigation.
But this has been given under what section?
My lord, ultimately 457, my lord.
Where?
Last para 13, I have read it, my lord.
Huh?
Para 13, my lord.
Yeah.
On balancing the competing claims, the court would have to make an overall view of the matter because question of right to possess would imply determination of ownership which arises only under 452 and 457 and not under 451.
But he has not really gone. Anyway, this is by a single judge.
No, single. I've just pointed it out, my lord. Then the other few points, my lord. Let us start with serial number 1, Ambika Roy, probably already cited that it is clear, my lord. Running page 2, 3, and 4, my lord. Just the paragraphs I'll read is para 1 first. The point involved in this rule running page 2, my lord.
Yeah.
The point involved in this rule is one of law raised in the backdrop of the new Code of Criminal Procedure. To be more precise, the point relates to the interpretation of section 457 of the CRPC 1973. That was the issue that was taken up by the
Ambika Roy, we have already read it.
Yes, yes, absolutely. I have given that, my lord, 1456. I read it in a better way, my lord. Then let's come to the second one, 1978, my lord, Kerala High Court. Running page 7 and 8, my lord.
Yeah.
Paragraph is, my lord, 4, 5, 7, 8, and 9. Your lordship can relate it with page A. This is again relying Ambika Roy's, my lord, case, my lord. It is true that in Ambika Roy's case, the property seized was produced in the court, but the fact happened to be mentioned in the decision only stating that it was not produced during inquiry or trial, so to come within 457. It was not held there that section 467 could be applied only if property was seized before the court. Yes, sir. The main line that your lordship is looking is at para 6, my lord. I read, my lord. The word such property is not produced before the criminal court during the inquiry or trial occurring at 457 has relation to 451 and 452 CRPC, which empowers the criminal court to pass an order both during and at the conclusion of inquiry and trial regarding custody of the disposal of the property produced before them. Those words have been used only to exclude from the operation of section 457 cases covered by section 451-52. Your lordship will now take note of it, my lord. There is no bar in 457 CRPC for exercising a power under it at the stage of investigation. Consequently, that power can be exercised at the stage of investigation. In that respect, there is no difference between section 457 of the new code and section 523 of the old code, my lord. Then in 7, my lord, it has been discussed both new and old code, my lord. And in 8, my lord, that is also relevant. Section 457 of the new code is wider in scope than 523 of the old code, because while 523 restricted its operation in seizure made under 51 and 550 of the old code, section 457 applies to all kinds of seizure under the code, my lord. All type of seizure, any seizure that is used. Well, furthermore, if you go, Bombay High Court, my lord, page 8, paragraph 8, page 11. But can I take your lordship directly to the point, my lord? Page 11, my lord.
Yes.
In the middle, my lord. It is thus not only in respect of the property regarding which an offence appears to have been committed or which appears to have been used for the commission of the offence that the court is empowered under 451 to make an order for custody and disposal of property pending trial. But even in respect of property produced before the court is empowered to make such an order. Now the line, my lord. It is not disputed that the car in question was produced before the court, and therefore the court was within its jurisdiction to pass
451.
pass an order for custody. My fact is that 451 and 457 distinguishes.
Look, the issue here is 457. It is not 451.
My lord, with all respect, I go a bit wider, my lord, because the reference that has been made before your lordship and while addressing the single bank, the question that cropped up in the judge's mind was that whether pending investigation and during investigation, interim custody can be given. That custody is not permanent. It is interchangeable also. It is neither an interlocutory order, neither a final order. As in the Amarnath case and many cases, it has been decided, my lord, and ruled, my lord, that it is an interim order of motion, my lord. Just for that particular moment, this order has been passed. It doesn't decide anything, my lord. Just certain arrangement has been made, my lord. So when the things has been produced, my lord, that is one, and when the things has not been produced is another situation, my lord. Because the opening line of 451 says order for custody and disposal of property pending trial when property is produced before the criminal court.
But then you see that Nevada properties, that,
Yes.
that judgment in Nevada properties, that has clearly stated that
That is regarding the bank account
custody
seizure
of
and-
property and all should be given only during the time of inquiry and trial.
Yes, absolutely.
So we cannot go to a period prior to the inquiry.
That is what, my
Yeah,
lord,
under
disturbing
451.
factor came from that judgment, my lord. para 37 or 47 of that Hardeep Singh case, my lord, that what is
Hardeep
inquiry?
Singh, yes,
At Supreme Court by constitutional
Where-
bench has said
yes,
that after charge sheet, before framing of charge.
where it
is
has
inquiry.
clarified what is
Yeah,
inquiry.
absolutely.
Huh.
But I did not agree. My responsible submission will be
No,
till
but-
today, my lord.
no,
I
no.
understand. My lord.
You may not be bound, but
No,
I
no,
am
no,
bound
no,
by
no,
this.
no, yeah, absolutely. My lord, what I say, my lord, today I may be wrong, my lord, because.
And
of the
that is a
Supreme Court.
constitution bench
Yeah,
judgment.
I'm
This
not
court
saying
is-
anything, my lord. But what
Uh,
I am trying to impress upon court, my lord, after reading so much of judgment from the various high court decisions emanated, my lord, that trial is always preceded by inquiry, my lord. And right from the investigation
No,
stage.
that is, even in Hardeep Singh, it has said that as soon as you file charge sheet and the time of framing of
yes.
charge, that inquiry is there.
But my contention is that, my lord, I say today, my lord, I don't know whether I will be proved wrong in the future or not, my lord. That investigation is for the police, field reserved for the police to do their investigation and do their job, my lord.
Correct?
Right, my lord? Now parallelly, what the court does, like sending a person to judicial custody and all, that's also.
Though investigation can be monitored by the court
A
also.
court also.
Huh.
That is why.
That has been, I think, already laid down by the apex court in various judgments.
That divine retreat. I
Only
think.
if they're not doing it properly. but
Yes,
that-
yes, to
That is the
monitor it.
precondition.
Absolutely.
Ah.
Or delaying the matter or
Oh,
favoring the
yes,
matter.
whatever
That
it is.
monitorism has been given to the judicial courts, my lord. Now, my lord, coming to my contention, my lord, that what the police done during investigation is for looking forward for the collection of evidence. H and Rizban case is clearly defined, my lord. What is investigation, my lord? Then, my lord, what the court does during that parallel time, my lord, all the proceeding, because ultimately, the moment the FIR is lodged, my lord, the launching pads of a criminal case starts, my lord. And it closes at the time of filing of the charge sheet. That is specifically clear, my lord. Now, the court's duty doing certain things during that period, from the court's end, my responsible submission will be inquiry, my lord. Because calling for the case diary under 173(2), my lord, if your lordship will see for granting bail, your lordship calls for the case diary. Then this can be called for during inquiry or trial to in the aid of. So while in a BA or AB, my lord, when your lordship is calling for the case diary, is making an inquiry. So whether what is he saying correct or not, whether he is doing correct or not, if your lordship kindly take the pain to look into
No,
173.
no point going into it now. Otherwise,
That's why I left
we are
it, my lord.
confusing the whole issue.
Yeah, but I being aware.
That will have to be considered in a different case scenario.
Yeah.
Uh-huh.
No, that's why I last time only I stopped it, my lord.
Yes.
But today I could find certain things. But I'll just take it to your lordship to certain glimpses, my lord. I've given the chart, my lord, so your lordship can have a look into it, my lord. Then coming to the Bombay High Court, my lord. Para 11, I've already let this Vale case will be very much pertinent, my lord. Let's come to page 14, my lord. That is Bharat Heavy Electricals Limited, Hyderabad versus state and the another versus the respondent, my lord. This, my lord, if your lordship will see what happened, Bhel was, my lord, transporting through the transporter certain equipments, my lord, for generation of power. So this man fled away with the vehicle, my lord. Police nabbed it, brings it. Now the property remains in custody of the police. So what purpose will be served and what in this type of situation, whether it can be given. So that has been, my lord, clearly held, my lord, at para 8 and 9. I'll read, my lord. Para 9 clearly speaks that, my lord. And this is while dealing 457, my lord. Can I read, my lord? 9, my lord. The only question for page 15, the only question for consideration in this revision petition is whether the petitioner company would be permitted to utilize the goods in their manufacturing process without waiting till the case is over. It cannot be disputed that normally it takes a long time. Herein is an extraordinary situation. The goods have to be used immediately by the petitioner company. The charge sheet has not so far been filed. It is true that under section 451, when any property is produced before any criminal court during any inquiry or trial, the court may make such order as it thinks fit for the proper custody of such property pending conclusion of the inquiry or trial. And if the property is suitable to speedy and natural decay, or if it is otherwise expedited to do so, the court may, after recording such evidence as it thinks fit necessary, order it to be sold, otherwise disposed of under 457 CRB. See, whenever the seizure.
Is this correct? Is this correct? And if the property is suitable to this speedy natural,
Decay, my lord.
is it is it there in the 457?
But there is a provision.
No, I think it's 459 maybe. Something.
Natural decay. असे की नाही police आहे सारे. 459 says specifically, my lord.
Yes. So you see, this is the wrong typographical error.
My lord, wrong
Supreme Court
code.
has it should have been written 459. It cannot be 457.
Here, my lord, property to deliver of such property to the person entitled to possession thereof, my lord. Your lordship got it right on the dot, my lord. Whenever seizure of the property by police officer is reported to a magistrate under the provision of the code, and such property is not produced before a criminal court during inquiry or trial, the magistrate may make such order so as we thinks fit respecting the disposal of such property or the delivery of such
It has not said anything.
entitled to the position thereof as a thing. No, my lord, here it is coming out, my lord.
No, it's not coming out. Out here, you see, whenever the seizure is reported,
Police.
I think it has confused.
Oh, a bit confusing, my lord.
459.
No, there is a bit confusion, but definitely it is on the line, my lord. Why I say the only question for consideration in this revision petition is whether the petitioner company will be permitted to utilize the goods in the manufacturing process without waiting till the case is over. It can be disputed that normally it takes a long time. So this way it is dealt with it, my lord. Then relying on that, my lord, again at page.
No, I don't think this case is applicable. Because when it says PD for decay, that points to 459.
Interestingly, if your lordship will kindly turn to page 16 and para 14.
16. Okay, yes.
One second. Just I am also enhancing myself, my lord. Para
Yes.
14, your lordship will see.
Yes, yes.
In view of this decision, I hold that since in this case, the charge sheet has not been so far filed, there is no inquiry or trial pending, and therefore order could not be passed under 451 CRPC, which your lordship is saying from day one.
Yes.
They could be passed
Under-
only under section 457 CRPC. This is what your lordship is always saying, my lord. Under section 457(1) CRPC, when the seizure of property by the police order is reported to the magistrate and such property is not produced before a criminal court during inquiry or trial, the magistrate may make such an order as it thinks fit respecting the disposal of such property or delivery of such property to a person entitled to possession. Therefore, the case in hand, I am of the opinion that the magistrate could pass an order directing delivery of the property to the petitioner under 457. Even if I am wrong, I could still direct the delivery of property to the petitioner company under 482 CRPC.
So he's not sure. He's not sure.
I have fairly read it, my lord,
Yeah.
for your lordship to
He's
draw
not
the,
sure.
draw
Because,
draw the
because he
conclusion.
says that even if I am wrong, under 482 I've got the power.
Maybe, my lord. But my duty to point it out fairly and squarely, my lord. Normally, the judges don't say that I am wrong, my lord.
He's basically saying subject to the final authority that may
Come
be
up.
made. Yes. So this is neither here nor there. Anything, any direct. you think this
Direct,
just
that
is
is,
all-
that
this
Ambika
all-
Roy's, my lord.
A little bit of guesswork and speculation is here.
My lord, let us go directly. I have given the booklet. Your lordship will definitely go through it. But I'll take your lordship 5 minutes time. At page 51, my lord.
51.
51, my lord. That is probably directly on the point, my lord.
Madhya Pradesh.
তুমি ওলাবি না? মেৰাখন নহ'ল।
Yes.
Yes, madam. Para 12 it starts, that is at page 51.
Yes.
Madam, in the middle, madam.
Yes.
I read, order passed under section 457 may or may not be an interlocutory order, and it depends upon the facts of the case. Judicial magistrate acquires jurisdiction to entertain an application under section 457 of the CRPC when police officer seizes the property and matter is under investigation before the police, but before property is produced before the criminal court during inquiry or trial. In such a condition, the magistrate may make an order of disposal of such property or delivery of such property entitled to possession thereof. If the magistrate passes an order touching the rights of the person over the property, then order will not be an interlocutory order. But if order is passed only by giving possession of property during pendency of trial, then such order will be an interlocutory order, and the criminal revision shall not be maintainable to bar it, my lord. Then another line. Para 13, my lord, just one more.
Para 13.
Yes, ma'am. Next page, page 52.
Yes.
Once final charge sheet is filed by the police and property is said to be involved in the crime, then only application under 451 of the CRPC is maintainable, which your lordship is saying from day one, my lord. In case of Ganesh versus State, relied upon by the applicant, police has filed a final report of no occurrence of crime and solicited the order of judicial magistrate. So final report was submitted, so that way it was given, my lord. So that is the only para number 12, which is directly on the point, my lord, and I've given the citations and with date. And there is one, my lord, one M. Ravindran case, my lord, regarding interpretation of the sections, my lord. How it should be dealt with when, if any such situation arises, my lord. Probably it is page 93, my lord, 17.9. Page 93. It's a big judgment regarding 164 CRPC remand, my lord. But while interpreting the statute, what should be the approach of the honorable judge?
164 is confession statement. 167 you mean?
167 CRPC, my lord. While interpreting the provision of 167, the Honorable Supreme Court had the occasion to look into the whole code right from the beginning till the end, my lord.
Yes.
So while interpreting the various provisions, my lord. Additionally, it is well 17.9.
Yes.
Additionally, it is well settled that in case of any ambiguity in the construction of a penal statute, the court must favor the interpretation which leads toward the protection of the rights of the accused, giving the unquestioned powers leads towards protecting the rights of the giving the power disparity between the individual accused and the state president. Now, next slide. This is applicable not only in case of substantive penal statute, but also in case of procedures providing for curtailment of the liberty of the accused. So that should have been, that should be the approach of the courts, my lord, while dealing with the interpretation of section, any section where ambiguity has cropped in, certain things are not clarity, not said with clarity, like inquiry word is not said with clarity, suppose. So all our things should, your lordship should be looking. So coming to the basic, just 2 minutes, my lord, I'll take your lordship. My lord, what is this 451 and 457? 451, we don't touch it because that is completely in a different parameter, my lord, in a different page still. 457 happens in this way, my lord, that when an investigation is on, police sees many a thing. Right, my lord? So now I have raised various judgments, facts, my lord, because criminal cases are basically decided on the factual metrics of the case. Only the legal proposition is supporting that notions, my lord. What is the legal position, my lord? Because whether a person is killed a person or not. Now the procedural lapses may be there, then all these things may be there, my lord. That is one aspect. But suppose a person, a driver was driving a vehicle, my lord, and he was carrying a pocket, in the pocket he was carrying some contraband. Police naps him, my lord. So for that, should the whole vehicle be seized and kept in custody, or the, and when it will be decided in trial is not known, my lord, when the charge sheet will be filed. That is Sundarbai Ambala's case says that. So what to do with those properties, my lord? Because the vehicle is innocent, the registered owner has not done anything. His servant has done, he has carried, he is responsible for the case. But why should the vehicle be allowed to be rotted? So these arrangements are made, my lord, by virtue of these laws, my lord. Because it is not the intention of the legislator that it should not given in favor of the persons, my lord, aggrieved persons, my lord. Now, I have read one Kerala judgment, my lord, I have seen, my lord, that a friend asked his friend his vehicle, my lord, to go to his father's place, my lord. The vehicle was given to him. He goes inside and starts smoking cannabis, my lord. Police comes and nab him along with the vehicle that it is used, since it was used inside the vehicle, so it is conveyance according to the section 36 of the NDPS. So the vehicle is also seized. Now that man has given the vehicle to his friend's son for as a good gesture. Now what will happen for the vehicle when the charge sheet will file, when the FSL will come? So to take note of all these things, my lord, this section 457 has been incorporated in the CRPC, my lord. Otherwise, my lord, there would have been, it will run amok, my lord, havoc, my lord.
But that is one aspect of the matter. The other thing is that that vehicle could have been used for carrying maybe 600 kg
No,
of.
no, that is, I'm coming in the next. But if in a vehicle, secret chambers are built specifically meant for carrying contraband, then the registered owner will also not get it. Because it is with that.
Supposing no chambers are built, but they're still carrying, say,
No,
600
carrying
grams.
them, that
Okay,
is
yeah,
now in a taxi, my lord.
no, not a taxi, is a private
No.
vehicle. If they're carrying, say, 600 kgs of ganja.
Yeah, maybe, my lord.
Then-
Maybe, no, that,
See, another thing, just the law earlier, I think, laid down was that the court should not interfere with the investigation.
absolutely, there is no doubt of it.
However, now lately the law is changing in a way that the monitoring can be done by the courts also. And that, so once monitoring can be done by the courts, then, so I'm saying that since earlier investigation could not be interfered with by the court, maybe that is the reason that courts, the legislators tried to ensure that this custody of the seized articles could not be given during the investigation stage.
One way.
Could it be that? Because that way it would ensure that there was absolutely no interference from the court during the investigation process.
Absolutely. My lord, what interference to what regard, my lord, to what extent? That is also to be looked into by your lordship. The facts remain that, as I have said, that a pistol has been used for firing and killing somebody. And if a person comes claiming that pistol, I am the license holder, it should be given to me. It cannot be given because that is a crime property, case property. But suppose that man was traveling in the vehicle, borrowed from some other person to go somewhere, and he shoots from the vehicle. So why the vehicle should now be required for custody? It's not a case property. It is a property seized during the course of the investigation. It is the property seized during the course of the investigation. So because of that, my lord, why should that person suffer? So that's why the provision of 457 comes in.
What about 102?
102 is the one aspect, my lord, that can be
When there
dealt
is
with.
when it has been used for a commission of a crime.
Then it will be there, my lord. Now the bank accounts are frozen, my lord. That is done under section 102, my lord. That Niveda's case is to that regard, my lord. That Niveda's case, earlier, my lord, bank account is not said to be a property, could not be attached. or
Now
could
it's
not
a
be-
property.
Now it has been there as a property. Even I didn't knew it, my lord. Pen drives is also a document, my lord, not an object, my lord. Pen drives, my lord, electronic evidence, my
I
lord.
think that's.
My lord, we concluded, my lord, we have tremendous faith what your lordship will do, will judicially do it, my lord.
Mr. Vijay Shekhar, there also.
Direct issue.
My God, another
Ah,
bench.
he might have got something.
Two of the judgments of.
PN Goswami, oh, Vijay
These two are my
Shekhar.
written argument and judgments. That's all from my side.
Yes. Yes, Mr. Vijay.
And I'm a just judgment.
This may be
Eh,
directly on
These are the judgments you have given us. And still some more coming.
Since
My
your
lord, but
lordship is.
since your lordship is looking directly to the point, I don't think there will be hardly 20% directly of the point.
There is hardly, there's not much.
Not much.
In fact, I don't think, besides three or four, five cases,
Yes.
no one has really gone.
That Ambika Roy,
Yeah.
the Ram Sharma.
We might not also not go into it, depending upon
Absolutely, you're
how
allowed.
the trend goes. Let us see.
No, this might have been referred by it's of Calcutta High Court of 1950. No, my lord, this SK Muktiar, my lord.
Okay,
It is, my lord, under the old act, my lord.
under the old act,
Under the old act,
under the old code.
under the old code, my lord.
Yes.
While my lord, it was 523 and 516
523.
And
523 is clear.
and 516.
523 is clear. 516 is applicable to 451.
Yes,
Huh?
516A, man.
516A,
it's applicable to, my lord, 451
451.
and 4.
So old code 523, so there is no dispute that anytime, at any time, the court could give custody or release the property to any person. That is not in dispute. Its only thing is that what they are saying is that because of the use of this word during, not produced during any inquiry or trial.
In that case, it
Now
will be the
that has
second
put an
case.
embargo, which
that-
was not there earlier. Otherwise, they could have used the same words that were there in the earlier code.
The 523 earlier code and the 457 of the is the parameter, my lord, same, my lord, almost. The same.
No, the wording is, that is what they are trying to project. That is what they are trying to project. But the wordings, the words used are different.
Lordship, can we have a look to this, my lord, judgment, my lord?
Yes.
First, my lord, this AR 54 Calcutta 350. my lord.
Yes.
I'm reading paragraph 3, my lord.
Paragraph 3.
Second paragraph, subparagraph, my lord. A perusal of section themselves as also the numerous decisions thereon would go to show first that section 516A and 517 deals with cases which have actually come up before the criminal code. They deal with an inquiry or a trial in a criminal code. Section 516A enables a magistrate to provide for the interim custody of the goods, provide the conclusion of the inquiry or trial before the court. Section 517 provides for the disposal of property after inquiry or trial is over. In connection with orders under section 518A, there is necessary to appeal because the order is not a final order and is subject to revision when the case actually disposed of by the criminal court. Such fresh consideration of the matter will be under section 517 of the code. Therefore, only an order under section 517 is made appealable. Where there has been no inquiry or trial in a criminal code, the proper section to apply will be section 523, which deals with first of all properties found on a person arrested without warrant by the police. Secondly, suspected stolen properties. And thirdly, when properties are found under such circumstances.
No, 523, there's no quarrel that the court has the power to give custody during the pendency of the investigation. That there's no quarrel. What you're trying to say is that 523 and 457 is parameter. They are saying no. They are saying that if it was, then the wordings would have been similar. It's not. So that is what is trying to say.
We'll take it, my lord. Then, my lord, let's come to, my lord, the Orissa High Court, my lord, next at page 4, my lord.
Yes.
1977, CRLJ 1902.
Yes.
I'm referring to paragraph 6.
Paragraph 6.
Page 8. my lord.
Yes.
From the aforesaid discussion, the following conclusions arise. Whenever the seizure of the property by the police is reported to a magistrate, his jurisdiction to act further under 457 accrues. Such report may be made either by police officer or by any other person interested. The expression as such property is not produced before a criminal court during an inquiry or trial in subsection 1 refers merely to a stage of investigation and not the stage of inquiry or trial. It is a condition precedent to the exercise of jurisdiction by magistrate under section 457.
So it's following the Calcutta High Court judgment. Bombay High Court, again we've got.
Bombay High Court, different judgments are there, my lord. Even I am referring to one of the Bombay High Court, my lord.
Yes,
2000 CRLJ 1078, party name Anup Kumar Kantak petition.
yes.
That is already, has your lordship got it? Page 9, my lord.
Yes,
They are referring to paragraph 16.
yes.
Page, my lord, 15, my lord, running page 15. my lord.
Yes,
As regard the jurisdiction of the magistrate to exercise the power under provision of section 457 CRPC, the same can be invoked the moment any property is seized by the police. The magistrate would assume jurisdiction to pass an appropriate order under section 457 CRPC. The moment a seizure of any property by the police is reported to the magistrate by any person having interest in the property seized, subject of course to any law in force to the contrary. The report of seizure by the police themselves is not condition precedent for exercising power under the said section by the magistrate. Likewise, the seizure would include any seizure by police, whether lawful or not, irrespective of the irregularity in the course of seizure. And once there is the seizure by the police, the jurisdiction of the magistrate under 457 CRPC is not curtailed. The power of a magistrate under 457 CRPC are wide, and it is necessarily too wide for proper check over possible abuse of power by the police personnel.
yes.
Then, my lord, one, my lord, the regular citation I could not get, my lord, it is from the India Kanun, my lord. Rajasthan High Court, page 20, my lord. Nandalal, my lord.
Yes,
I am referring to, my lord, para 7, my lord. Page 22, my lord.
single bench.
Single bench. my lord.
Para 22.
Para 7, my lord,
Para
page
7.
22.
Yes,
Section 457 CRPC applies to a situation where the seizure of the property by any police officer is reported to the magistrate under the provision of the code, but the property so seized is not actually produced in court and enquiry or trial has not commenced at all. In my view, the provision of section 457 CRPC are applicable where the property is seized by the police during the investigation, but no enquiry or trial takes place. Where the magistrate declines to take cognizance of the offense, the natural consequences is that there is no inquiry or trial before him. In such a case, like the instant one, where negative final report is filed by the police and is accepted by the magistrate, the provision of section 457 CRPC would be applicable. I am profited in my view with the decision of this court. A magistrate competent to pass appropriate order for disposal of the property under section 523, now section 457 of new CRPC, even in cases where there has been no inquiry or trial, and consequently also where the police have submitted a final negative report stating that no offense has been made out. The provisions that must suffice. So, my lord, this is, my lord, that it has the power, my lord, that's what I said. And second, I have submitted, my lord, this Sundarbai case, my lord, it has laid down guidelines in the form of law that has been, my lord, accepted by many high courts, my lord, referred to as the, my lord, rules framed by the my lord, apex court.
with regard to where?
Sundarbai.
Ambalbhai Desai's case.
Sundarbai Ambal Desai, my lord. Some guidelines have been given, even the direction have been issued there, the registry of the, every high court should, my lord, maintain a register to
Where
check.
is the
and-
citation?
That your lordship will file in all the judgments, my lord. That is already taken note of your lordship.
I've taken note of.
Yes, sir. On the first day, we are banking on that heavily.
Sundarbai Ambaral Desai.
Desai.
Yes, the guidelines that have been framed, but it is for both 451 and
For that,
457.
15 days, 1 month.
Yes,
Those
yes.
those issues.
They want your lordship say.
So they are not, matlab, there is no distinction between 451 and 457 in that judgment, and that way has been accepted by various high court as the rule framed by the high court. Madam. So my submission that this will also be in law. Madam.
Yes.
Well, just 2 lines
Yes,
adding,
yes.
my lord. Sorry to interrupt, my lord. So that Sundarbai Ambala's case and Prudential Insurance Company Consortium case, I have referred it last time, your lordship has got it, my lord.
Which case?
That insurance company's case, my lord.
Insurance company, is it here?
Yes, my lord. The theft of the vehicle I cited. Your lordship is aware, my lord. Got it, my lord.
Yes, so many.
No, no,
documents you have
uh,
cited.
Yes, that time we did
Already-
not make it in a
already
booklet.
such a thick file.
Well, only my last contention, my lord. If your lordship will kindly turn to page 33 of mine, I have left that important judgment. my lord.
33.
33, my lord.
Yes.
So bear it so much, just 2 minutes. That is para 19, my lord.
Yes.
In this case, para 19, fourth line. In this case, charge sheet has not been filed and the case is only pending investigation. Therefore, there is no inquiry or trial pending. No orders could therefore be passed under 451. Orders could be passed under 457 of the CRPC. Then, my lord, at page 34.
Just a minute.
Yeah, sure, my lord.
This is, which case?
This is from the no, Kerala.
Kerala High Court.
Yeah, Kerala High Court. Different in 86, my lord. Because the order was passed under 451 by the magistrate, the court treated this to be an order under 457, my lord. Because the High Court was the view, no 451 will apply because since it is not in the inquiry or trial stage. Only before inquiry and trial stage, 457 comes into play.
No,
So-
but why?
My lord. Yeah, after your lordship will now come, my lord, taking para 22 into consideration, the lordship view has been expressed, my lord.
Yes.
In view of this decision, I hold page 34, my lord. In view of this decision, I hold that since this case, charges has not been filed so far, there is no inquiry or trial pending, and therefore order could not be passed under 451 CRPC. They could be passed only under 457 CRPC. Under section 457(1) CRPC, when the seizure of property by police is reported to a magistrate and such property is not produced before a criminal court during inquiry or trial, the magistrate may make such order as it thinks fit in respecting of the disposal of such property or delivery of such property to the person entitled to the possession thereof. Therefore, in this case on hand, I have the opinion the magistrate could order an order directing deliver the property to the petitioner company under 457(1) CRPC. Even if I am wrong, I could still deliver the property company under 482
Then-
CRPC.
Even if I am wrong.
Yes, but that line I don't know, my lord. Then relying on that, that is judge's word, my lord. Then 23, Bharat Mahe versus State of UP relates to a similar matter in a crime which was pending investigation. In that decision, the Allahabad High Court said the impugned order finally disposed of the teens of Dalda. It is not an interim arrangement for the delivery of custody of the production of the case property as and when required by the court. The corpus of the teens will cease to exist on the sale. Hence, it cannot be said that the sale proceed would adequately represent the corpus of the property. On reading of section 457(2) and 458(1) CRPC, the position is clear that both final order and temporary orders with regard to the disposal of seized property are contemplated under these two sections. That is 457 and 458. That is the final delivery. But interim custody is always under 457. The criminal reason is allowed and the investigation agency will see that the alleged exemption article 6 in this case be sound and track expert is convicted. And that's so now your lordship is going to clear so many ambiguities, my lord.
No, we're not going to clear too many. We're just going to
He has given a
take a decision
good
on
note, I
one,
believe, my
small issue. that's
though I
all.
haven't seen it, definitely it will be a good one.
We also might say, even if we are wrong, 482 is what.
But honestly, my lord, we haven't seen this type of language coming in judgment, my lord. For the first time, I've seen it, my lord. Earlier, throughout, I've not seen the judge himself saying, I am wrong, but I'm passing this order. Judges say positively, I'm always right, so I'm passing this order.
So and not one high court, two high courts.
Two high courts, interesting. Probably one borrowed it, my lord.
Probably borrowed. But the problem is now we are stuck with the.
The problem states remains. my lord.
Yes.
Now it's up
And
to
the,
your
and the
lordship.
pro- and the problem is more with the volume.
Yes, ma'am. No, your
You see
lordship
this?
can filter down, my lord.
It will go down, my lord. Loose copies will no longer be required. Everybody has filed compilations, my lord. That will.
Your lordship can filter down because all the points.
But I'll
directly-
have to read again. No? I'll have to, maybe we might not put everything in the judgment, in the order, because it will be too bulky otherwise.
Too bulky. No, because your lordship will not be expressing anything regarding the facts, only straight with the reference and the
Yes, only
answer.
that, only that. But then still, if you all,
Yeah, of course,
if you
yeah.
all want us
No,
to,
there are sets of lawyer also.
we'll have to, I think, maybe make a mention of all the judgments.
What has
And-
been at least stated.
Yes, and the judgments you all have mentioned are not less than, I think,
Yeah, I'm
not less
just,
than 35.
Mala, I'm just suggesting, not saying anything,
Yes, yes.
that whatever we have said, your lordship will take note of it, but will rely only those who are relevant to it.
Look, basically, your submissions are basically on the basis of judgments.
Yes, absolutely.
There's nothing else.
That's the legal
There's no,
aspect,
there's
my lord.
no, there's no separate
Newly
submissions
built
made.
up things, my lord.
The point that you were trying to bring up, I don't think we can go into that issue because Hardeep Singh's case is there very clear.
That is
Yes.
the biggest hurdle
Yes.
right now, which
So
have.
I don't think we'll go into those issues. Because Constitution bench judgment is already.
No, had Hardeep Singh not been there, my lord, I would have raised that contention, my lord.
Uh-huh.
Inquiry and investigation runs parallelly, my lord. But we are also handicapped by following that, because it's an Article 141 judgment, my lord, you have to rely. Same way, my lord, Sundarbhai Ambala's case also.
And
141.
also the expansion of the provisions of 451, the jurisdiction, I
Yes.
mean the power.
Power.
I don't think we can go into it because there are decisions of the apex court which has limited the role of 451 to that only pertaining to those properties which are produced during inquiry and trial.
Correct. That is when the case is on, my lord.
Yes.
For
that's
exhibiting,
it, yes.
exhibiting it.
So
my lord.
we will basically limit ourselves as to this 457
No,
and the meaning of those words and
Inquiry, trial.
not produce during
Not
inquiry and trial.
Absolutely. That these are the three words probably, inquiry and trial and not produced, my lord. Rest are all the same, my lord. Whether that time custody can be given or not, that is.
Because you have got to keep in view the fact that 459 is there also.
Yes, 459.
459 on
that
the
is
other hand gives
perishable, my lord.
perishable. So if perishable can be given under 459, why not unperishable
Unpaid.
under 457?
7, absolutely. Now, nowadays, a new
Wow.
trend has come up, my lord, that a cattle acts, my lord.
Hmm.
So much of cattle smuggling is going on, my lord.
Uh,
It is seized, my lord.
uh.
Now what to do? So these things come up. I have cited the judgment, of course, my lord, that this
But then that is for
goshalas.
won't that be for the legislature to decide?
No, the acts are vague actually. One word, two words will suffice the whole matter, my lord. But this, your lordship can take note of it also.
No, because one thing is that if there is a provision for property that is going to be subject to decay, speedy decay. Why confine yourself only to those specific type of properties?
Paddy, because
Why
in
not
harvesting
all
time-
types of properties? Why specifically to that? Why is it barred?
Earlier, we have lots of cases when people used to go to the paddy field for cultivating it. During harvesting time, one says, I have cultivated it, this is mine. Then a fight ensues, my lord. Then one is killed. Then all the paddies are seized. Now what will do? It will perish. Nobody is going to get it, my lord. So somebody comes forward. Sometimes it is deposited in the treasury, my lord, the proceed. So facts remain now, my lord.
Let us try our best.
Well, sure, my lord. I'm
We-
sure
we-
something
we
good will
might
come
say
out.
At the end, even if we are
Hopefully,
wrong.
we are all expecting something because it's a legal interpretation, nothing to do with the factual winning situation or some losing situation. Just my lord, that what the law says, my lord.
What the law says, which should help everyone.
Yeah, absolutely. On the contrary, that's why I've relied upon the 19.7 Ravindran's case, my lord. Much obliged, my lord.
Deeply obliged.
Item 9, your lordship, Ms. Bhuya has seen the matter. She'll be coming soon.
Okay, coming
If your
to
lordship takes it up after some time, 9.
9. No, I think the facts are very clear.
9,
There's no, you're for 9.
I'm for 9, my lord. I'm only arguing upon a sentence, my lord, because there
I
was-
know, you're under the exceptions.
There's no
There,
premeditation. my
there,
lord.
that is your case.
There is no premeditation as
Your
such.
basic case is that,
He was attacked, my lord, and he saw, my lord. And I possibly found the judgment, my lord,
Huh?
quite similar, my lord. Father, son, my lord, everything is quite similar facts. My lord. There is no premeditation, my lord. That is a fact. No premeditation. He acted upon a grave and sudden provocation, my lord. That is there, my lord. The father came with that stick or whatever, my lord. And not, he didn't act in a cruel manner. my lord.
but is it as per the evidence of the witnesses?
His
Of
one
the
six,
PW1 witness?
my lord, PW2 is that stepmother, my lord.
Ah.
She says that there was scuffling. She saw the killing blow. But then PW5 my lord says that she informed him that there was a fight ensuing. She came to inform me. We both went and saw the dead body. my lord.
No, so
Yes.
after the incident, she must have gone and called him.
As per PW5, my lord, during the incident, because she could not break off the fight, my lord, she came to the PW5. They were both went, my lord. And his 164 is there, although he has resigned later on in working with 313, my lord. He states specifically, my lord, that the facts, my lord. And one thing is there, my lord, possibly they were mistreated, my lord. That is there on record, my lord. His younger brother committed suicide, and that
But they were all living in the same compound.
no, my lord, no, my lord, separate, my lord, separate, my lord. That I-
Nearby,
Huh?
nearby but
nearby,
separate.
but separate.
They were thrown not they were removed from the property
Compound.
by the
By
deceased,
the
my lord.
deceased.
The mother and the other two sons, my lord.
Yes, what have you got to say? You're for the
I'm
informant.
for the informant.
Yes, what is your stand?
My stand is basically, Lordship, that the accused has been changing his stance. He has been examined as DW1. In that, he is depicting a different story that first the father came to their house, met with some quarrel with his mother.
Mother.
Thereafter, in a rag, he went to his father's place. Thereafter, something happened. Thereafter, he said that father attacked first, so I also. So, and thereafter, he told that after snatching hold of the axe, I threw it away. But thereafter, how the injuries got, he was not aware.
That is doing defense with
But,
I'll confine
but
myself
in
to his only 160.
164 statement, he is saying something else.
He surrendered,
And
my
his
lord.
mother is saying something else.
Mother and
So each
164 are
and-
similar.
But mother means Lordship is own mother.
Own mother, own mother.
She is stating that something else, but she has not narrated regarding the incident that happened and told by her son, Lordship, that there was something.
Okay, let us go to the evidence.
Lordship.
My lord, Lordship may go to this 164, my lord, if Lordship previous one.
Page.
Page 86, my lord. Page 86 is 164. my lord.
Page 86. Yes.
It starts, my lord. Earlier, my father served in the Indian Army. And after his retirement in 1997, he returned home. My younger brother, mother, and I lived in our house. After consuming liquor, my father used to beat my younger brother, mother, and me. My father drove my younger brother and mother out of the house some 7 years ago from today. And for that reason, my younger brother went to my maternal uncle's house and committed suicide there. Without bringing my mother back to the house, my father married another woman and brought her home about 6 years ago. Later, as my mother lodged a case against my father, the later gave 1 bigha land to the former near his house to construct a house thereon. My mother and I constructed a house on that plot of land and lived there. My father did not give any share of his pension amount to my mother. My father did not give us any cultivable land. Later, I went to Hyderabad to work there. I returned home from Hyderabad to enjoy Rongali Bihu. One day, I approached my father seeking landed property from him, but he did not give me any landed property. On Tuesday last, my father came after consuming liquor and hurled abuses at me. He also told me that he would not give me any landed property. And then I asked my father not to abuse me. And I also told him that I would go to Hyderabad again. My father did not accept me as his son and he scolded my mother using very filthy words. My father asked me why I had not married yet. He also told me that I had illicit affair with my mother. Then, as it enraged me, I went near my father. Then my father punched me and made attempt to assault me with a fence post. Fearing that my father would assault me, I went inside the house. While entering the house, I found an axe on the door. And in a fit of anger, I struck my father on his head with that axe. Then my father fell down. When I went towards the road, my father attempted to assault me with stones. Then I dealt an axe blow to my father again. Thereafter, I left that place. Later, I came to know that my father had died. Thereafter, I appeared at Borpatha police station, and I have this much to say. He surrendered, my lord, immediately. He gave his 164, my lord.
You should. You have hit him twice on the head.
He died because of the neck injury, my lord.
Neck injury. Okay, once on the head. Now, this 164 was exhibited by you,
Yes, exhibit
Exhibited during trial, my lord,
exhibited by
by the prosecution.
the prosecution. By whom?
For the pastry,
Who is the PW number?
PW 9, my lord, page 26 is the magistrate, my lord.
Huh?
PW 9, my lord, page 26.
PW 9.
9. Well, from my humble submission from the 164, my lord. He had no intention to kill his father, my lord. And it is a fact now the altercation took place, my lord, and some words that should not have been said, my lord, or possibly said, my lord. And he was attacked first, my lord, and then that happened, my lord.
Where did this incident occur, according to you?
It occurred in the father's property, my lord.
Father's property.
Father's property.
And your property is where? How close to your
It's
father?
nearby, my lord. Sketch map is possibly there.
He resides with his mother.
How far is his property from the father's property?
Page 89 is the sketch map, my lord.
Page 89.
Therefore, indicated my house in the sketch map, my lord. Does not be indicated in the sketch map, my lord, but from the evidence it comes out that it's quite nearby, my lord.
Who is Munu Bora?
Munu Bora is PW 6, my lord.
Who is he?
He is one of the
Brother.
He's the uncle of the appellant,
And
brother of
this,
the deceased.
Mohendra Bora?
Mohendra Bora.
Not an examiner.
No, not it.
So your house is somewhere away, not adjacent.
Not near, it's nearby, my lord. From 164, he says he brought up 1 bigha piece of land near.
I know, but it's not adjacent.
Not adjacent, my lord, nearby. It's not in the sketch
Lordship,
map.
evidence of PW8 who happens to be the mother of the accused person and first wife of the deceased. I think something will come out from that, my lord. PW8. Halimi Bora.
Page 24, my lord.
Please,
24, my lord.
24. Yes. Lordship, I saw
Mother
of the deceased, mother of the accused, first wife of the deceased. She says, my lord, she deposes at page 24, second paragraph. I do not stay in that house, but I stay in a separate house a little distance away from that house. Biren Bora used to stay with his second wife.
Sir, may I read, my lord? The mother, my lord. Mother is very important.
Yes.
The incident took place in the evening hours on 28th day of April, Pohag in the house of deceased Biren Bora, the father, my lord. I did not stay in that house, but I stay in a separate house a little distance away from that house. Biren Bora used to stay with his second wife. At the time of the incident, I was at home. In the evening, when I went to tether cattle and the goats, I saw Biren Bora lying a little distance away from the house. Thereafter, I heard a commotion. Then Digonta Bora, the nephew of Biren Bora, came out and told me that he had seen injury on the person of Biren Bora. Digonta Bora is PW3 minor. Then I went near the dead body. Going there, I became speechless. After a while, I could learn that my husband, Biren Bora, had died. Then I returned to my house and met my son there. He told me that Biren Bora had rushed at him and assaulted him, and that he had assaulted Biren Bora with an axe just to save himself. The axe does not belong to my house. I am not aware if it belonged to Biren Bora. That's all I know. Cross Malot. Biren Bora married his second wife after his retirement and drove me and my two sons out of his house. I myself erected a house and stayed there. He did not provide me any maintenance. He also did not give me the share of his properties. I was staying separately on the land belonging to my brothers. Even though I stayed separately, he tortured me and caused damages to my house. I informed the police about it, whereupon they sent us back after settling our disputes. Even after that, he tortured us again. My other son, being unable to bear the torture meted out to him by his father, committed suicide. Prior to the incident, the accused had been working in the company in Hyderabad. Biren Bora made a false allegation that I have illicit affair with my son. On the day of the incident also, Biren Bora came to my house and assaulted me. Then my son was not at home. When he came home, I told him that Biren Bora had come and assaulted me. Then he went to his father to ask him why he had assaulted me. Then his father assaulted him and told him that he had an illicit affair with me. Then my son could not bear it, and as his father rushed at him, he killed his father to save himself.
Now let us look at PW2.
PW2 is page 12 now.
Huh?
Page 12 now. The stepmother.
Second wife.
Yes,
Second
she's the
one.
informant, madam.
She's the informant second. This is Biren Bora was my husband. I am the second wife of my husband. His first wife is still alive. Accused Ramesh Bora is the son of my husband from his first wife. This is Biren Bora used to live separately along with me, while accused used to live separately along with his mother. The incident took place in the month of Bohag, April-May this year. Around 7:30 p.m. one day in the month of Bohag, my husband was returning home after herding the cattle, and no sooner had he reached the gateway, the accused hacked him thrice on his neck. He also hacked him on his belly. At the time of the incident, I was at the frontal part of the house and I witnessed the incident. The accused came straight and hacked him. Thereafter, the accused brought my husband to the courtyard by holding him and laid him there. I do not know why he had assaulted him. I immediately went to the house of the VDP secretary and informed him of the incident. I do not know his name, but he is addressed as Baba. This is PW5 minute.
Lordship, gentlemen are standing on the back.
Okay. Yeah. So out here, the wife or the second wife has basically stated that there was not, you had attacked him. There's nothing to show that he attacked you.
May I read PW5 when watching?
After lunch.
Please.
Yes.
No, we had read PW2, my lord.
Second wife, yes.
Second wife. PW3 is the uncle, my lord. Page 14.
So second wife She says that husband was returning home after herding cattle,
Yes.
and no sooner had he reached the gateway, the accused hacked him thrice on his neck. He had also hacked him on his belly. Now that is quite a 4 times. That is that in self-defense or something?
But
I
the
mean, private defense.
PW5 says something else, madam. Regarding the PW2's version.
PW5.
PW5 is the VDP secretary who she directly informed, madam. Page 18, madam.
Yes, PW5. Yes.
I know the accused present in the dock. I knew deceased Biren Bora. I also know informant Monju Bora. Second one. On evening about 3 months ago, the incident took place in front of deceased Biren Bora's house. At that time, I was at home. Since I am the VDP secretary of village Rotnapur, Biren Bora's second wife approached me, informed me that a fight had started between the accused and Biren Bora.
But fight had started.
My lord. Since she could not dissuade them from fighting, she came to me and informed me about it. Then I came to the place of occurrence and saw the accused splashing water on the road with a bucket.
Accused splashing water on the road.
With a bucket, man.
Why? To clean the blood.
My lord, he says in his C13 that he was putting water on his father's this mouth. He felt, my lord.
How much water will you put in the bucket?
But he said that he was putting on his mouth. Man.
With a hand or with a.
But that fight took place, that is there, my lord. Other witnesses also to that effect, my lord.
No, you see one thing. If you carry on reading the evidence of PW5. He was splashing the road with a bucket. Correct.
On being asked,
Splashing water on the road with a bucket.
my lord.
On being asked, the accused replied that he had a fight with his father. When I asked him where that person was, he replied that he had pulled him to the courtyard and left him there. So there was no question of giving him water on the road because he was already in the courtyard.
My lord, that he says in 313. I think I'm pointing out to Lordship. I'm only pointing out to Lordship, my lord. He says in 313 that he was putting water on the mouth.
Where is that evidence?
And my lord, Lordship will see the second paragraph, my lord. The last line, my lord. Last but second line, my lord. I did not know over what matter the quarrel had taken place. The deceased used to consume liquor. He used to cause nuisance sometimes.
How does it matter? Sometimes
in the
people
cross, my
drink,
lord.
sometimes people
And in the cross, my lord, again, it is from the cross it comes, my lord. First, second, third, fourth, my lord. Monju Bora, PW2, told me about the quarrel that took place between the father and the son.
What is this? What is this cross-examination?
Cross, my lord, page 19.
Yes.
First, second, third, fourth, my lord. Monju Bora told me about the quarrel that took place between the father and the son.
Manju Bora is the
PW2, the second wife.
Second wife.
The second wife is consciously silent regarding the fight in her deposition. Ma'am. That she will obviously she wants to possibly succeed, my lord. Husband has been killed, my lord. But that fight on the face of the record took place, my lord. And it was regarding that comment made about the mother, my
What
lord.
about the splashing part?
Splashing part, that
Carry on reading. It is not a fact.
it is not a fact that I falsely deposed that the accused was splashing water on the road. It is not a fact that the accused did not tell me that he had assaulted his father and left him on the courtyard. It is not a fact that I have adduced false evidence in the court. When again, my lord, PW6, my lord, another uncle, my lord, brother of the deceased, my lord, page 20.
Yes. Yes.
May I read, my lord?
Yes.
One evening, some 3 months ago, the incident took place on the road in the gateway of deceased Biren Bora's house. At the time of the incident, I was doing carpentry work nearby. I reached home at about 8 p.m. My house is near the house of the deceased. Arriving at home, I could learn about the incident. Hearing a commotion in the house of Biren Bora, I went there and saw the dead body of Biren Bora lying on the courtyard. I came to know from my elder brother, Chandra Bora. Chandra Bora is PW4, my lord, that the accused had a quarrel with Biren Bora and that the accused had killed him with an axe. Arriving at the place of occurrence while the police was examining the dead body, I noticed cut wounds on the right side and the left side of the neck of the dead body. Cross part, my lord. Biren Bora retired from his service some 15 years ago. Thereafter, he had been living near my house along with his wife and 2 children. Viren Bora used to beat and torture his wife and two sons under the influence of liquor. His younger son, Ritupon, being unable to bear his father's torture, committed suicide. He entered into marriage again with a woman by the name of Bonju Bora about 12 years ago from today, and he drove his first wife and the accused out of his house. Then he constructed another house nearby for them. They were not given any land for cultivation, nor were they given any share of pension for their maintenance. Even though they stayed separately, Biren Bora used to torture the accused and his mother. Biren Bora and his second wife Monju lived in the old house. Biren Bora alleged that the accused had illicit affair with the latter's mother. The accused went to Hyderabad for doing a job and he returned from Hyderabad during Bihu festival. Thereafter, the accused was tortured by his father.
How? Tortured how?
So he says in his 164 Malad. It's continuous Malad.
Continuous.
Possibly Malad. I not sure that.
So he was tortured. How was he tortured? He was beaten up by a stick, beaten up with his hands,
What he did.
or he
say-
was tortured with words. How was he tortured? There have to be. You have got to give specific.
On the record, Malad, the family members say that under the influence of alcohol, he used to torture his wife and both sons, Malad. And the younger son, Malad, the younger brother, the appellant, Malad, committed suicide because of the torture, Malad.
That's a different issue. You see.
That is on the
Now
record. And then, Malad, on the day of the occurrence, Malad, I will again come back to his 164, Malad. In Assamese, he said, Malad, in Assamese, he said, Malad, the biya pata nahi kyo? Makor logot, Malad, in those illicit, that Malad. Then the fight, he went to hit Malad, then the fight took place, Malad. Had that provocation not been there, Malad, this unfortunate incident would not have happened, Malad. That is my humble submission, Malad. Because he did not go there with the premeditated mindset to kill his own father. Malad. That is possibly not there on the record, Malad, humble submission, Malad. And Malad, that he did not go there with the dao, Malad. He found the dao in the house, Malad, when he was running away, Malad.
he was running away where? Running away into the house or running away outside the house? Or where was he running away?
He saw, he was there, Malad, one thing is there, Malad, came to my mind, Malad. From childhood, he has been possibly been abused, Malad. That is, I'm only for argument,
We
Malad.
cannot do. We cannot.
I'm only
speculate.
for the sake of my argument, my lord. That mindset is there, my lord. His father is there coming with this. I must.
How
run away.
old was this? How old is this person? Apparent?
He was quite old, my lord. May I- One
31
second.
years at the
Huh?
time. 31 years.
31 years.
2016.
He's not a small. He's not a
30
young boy
years.
anymore.
30 years.
30 years.
30 years. Not. I'm not saying that he was small. I'm saying that, my lord, from childhood, that fear it grows bigger and bigger and bigger, my lord.
I don't know. We don't know.
So may
You have to show us from the evidence.
my lord. And then, my lord, another thing that comes to my mind, my lord. His own mother, I've already read, my lord.
His own mother already dead.
Then he gives his GW, my lord. That is
So he comes under which exception?
possibly fourth, my lord.
Huh?
Possibly fourth, my lord. No premeditation, my lord.
Fourth.
Fourth, my lord.
Let us see.
First or fourth, my lord.
First or fourth?
Yeah.
I don't know. You tell me. You're the counsel.
First is, my lord, exception one, my lord. Culpable homicide is not murder if the offender, while deprived of the power of self-control by grave and sudden provocation, causes the death of the person who gave the provocation, or causes the death of any other person by mistake or accident. Exception one, my lord. And exception four, my lord. Culpable homicide is not murder if it is committed without premeditation in a sudden fight, in the heat of passion, upon a sudden quarrel, and without the offender having taken undue advantage or acted in a cruel or unusual manner.
So if the
that point, my lord, that
And was
boiling
there-
point was reached. My lord.
Where is that sudden fight that occurred?
This is 164 Mayor reached, my lord.
161.
164, my lord, the
164.
appellants,
Confessional statement.
page 86. My lord. Seventh line from the bottom, my lord.
Yes.
On Tuesday last, my father came after consuming liquor and hurled abuses at me. He also told me that he would not give me any landed property. Then I asked my father not to abuse me. And I also told him that I would go to Hyderabad again. My father did not accept me as his son and he scolded my mother using very filthy words. My father asked me why I had not married yet. He also told me that I had illicit affair with my mother. Then, as it enraged me, I went near my father. Then my father punched me and made attempt to assault me with a fence post. Fearing that my father would assault me, I went inside the house. While entering the house, I found an axe on the door. In a fit of anger, I struck my father on his head with that axe.
This is supposed to be a confessional statement, not supposed to be some statement where you start, putting allegations against someone who cannot cross-examine you.
No, this is his, what had actually happened, he has stated, my lord.
Okay, then.
Then my father fell down, and when I went towards the road, my father attempted to assault me with stones. Then I dealt an axe blow to my father again. Thereafter, I left that place. Later, I came to know that my father had died. Thereafter, I appeared at Borpatha police station. I have to say this much only.
This is the translation.
This is the translation, man. What had actually transpired that day, my lord, possibly he has said, man. Hey, my lord, may I read his own mother again, my lord? Lordship permits me. PW 8, my lord. Page 24, my lord. Page
You see,
25.
but then to you have struck him with an axe. What has he struck you with?
Axe, my
What-
lord.
X.
Axe, my lord.
No. He has struck him with an axe.
Oh, here I have struck with an axe, my lord.
But the other side, the disease, what did he have?
He had a fence post, my lord.
Fence post.
A fence post. He did not go there with the axe, my lord. Had he gone there with the axe, my lord, I would not have argued for. He saw it.
But
saw
then
it
where
there, my
was
lord.
he hit? He was hit on the gateway to his own compound,
He was hit, my lord.
not in your compound. Correct. Where was the location, place of occurrence? Place of occurrence, as per the sketch map,
Place of
is
occurrence, my lord,
nowhere near your house.
is on the road, my lord.
On the road, let us see the place, where is the map?
Page 89 is the sketch map, my lord.
Page 89.
A is the
Page 89A. So on the road, just
on the
in
road,
front
ma'am.
of their house, in front of their compound.
in outside. Just
And
outside.
where is your house out here? Your house is nowhere to be seen.
Not in the sketch map, my lord, but it's nearby, my lord. From it,
Nearby where? But
Again-
whatever it is, it has been done on the road. It's not been done in their house or something.
but he carried, he dragged the deceased, my lord, towards the road, my lord. Possibly grievance and provocation was there, man. Possibly, man. The provocation part was possibly there, man. And there was no premeditation, man. May I seek my lord's permission, indulgence from, may I place some judgments, man?
Did you give evidence? Were you?
I was
huh?
examining a defense witness, my lord.
You examined a defense witness.
Yes,
Let
ma'am.
us see your evidence.
It is page 31, man.
Page 31.
Here, my lord, one thing I must point out, my lord, here he says the father got the injury when he fell down on the down. Here the accused has differed from his earlier statement, my lord. In DW, man.
So what does that make you? If you have differed from your earlier statement, what does that make you?
Well, pointing out the facts as I see.
No,
it.
no, I'm asking you a question. I know you're pointing out the facts, but I'm asking you a question.
My lord, what came to my mind, my lord, immediately when the occurrence, my lord.
What do you think of a witness who changes his stance?
Lord,
Is he reliable or not reliable?
Unreliable, my lord. Unreliable, my lord. But immediately, my lord, that proximity of my lord, he surrenders, he confesses, my lord. That repentance, that remorse is there, my lord.
Naturally, it's your own
My lord.
father you have killed.
My lord. That
Who
is
else?
why I'm saying, my lord, that intention to kill was not. That is why I'm saying, my lord, that intention to kill was. Subsequently, my lord, he has been in custody since the date of occurrence, my lord, never out on bail, anything, my lord. After 7-8 years, when somebody is inside, my lord, somebody gives some suggestion, my lord, possibly, my lord, in DW, say this. He was 31. DW page 31, my lord. When I met, may I read, my lord?
You see, let us your mother, what is that? PW number
PW 8, my lord.
page 24.
Page 24, my lord.
You see, you have said out here in your evidence at page 31,
My lord.
around 12 noon, the second paragraph, around 12 noon, I went out, page 31.
My lord.
I went out to attend the feast held in the school. I returned home in the evening. Arriving at home, I found household articles broken and furniture lying scattered. When I asked my mother who had done this, she remained silent. But a minor girl of the family of my parental uncle told me that my father had assaulted my mother. Then I went to my father's cell. Now coming to your mother's evidence at page 24.
My lord.
Silent. She is nowhere stated.
She sits in cross, my lord.
Huh?
In cross, my lord.
Okay.
The second paragraph. Prior to the incident, the accused had been working in a company in Hyderabad. Biren Bora made a false allegation that I had illicit affair with my son. On the day of the incident, also Biren Bora came to my house and assaulted me. Then my son was not at home. When he came home, I told him that Biren Bora had come and assaulted me. Then he went to his father to ask why he had assaulted me. Then his father assaulted him and told him that he had illicit affair with me. Then my son could not bear it. And as my father rushed at him, he killed his father to save himself.
But where is household articles broken? Things are coming out in cross-examination. What is it?
That is the thing.
Huh?
Because that shows the inexperience of the
Lawyers.
case brought, which has not come on.
In chief, she has said, he told me that Biren Bora had rushed him and assaulted him, and he had assaulted Biren Bora with an axe to save himself.
Your father was armed with an axe. That's your case.
Hello?
Huh?
My father came to assault me, Malo. I ran away.
No, out here you have said in page 32. No
In
sooner
32
had I reached the gateway than my father threw stones that I hid myself behind the chakwa. Then my father, armed with an axe, rushed at me with the intention to kill me.
Malo.
I grabbed hold of the axe. Thereafter, both of us engaged in a tussle. During the tussle, the bamboo chakwa and the fence got broken and both of us fell on the road. My father released the axe from his grip. I threw away the axe. Thereafter, my father became unconscious and fell on the road. Now, as per this evidence of yours, you did not hit your father with the axe.
That is why I said, Malo, he changes his statement, Malo, in the beginning only. Father fell down on the axe. That is his statement in DW. But My argument is that the proximity that, my lord, that 164 is surrenders everything, my lord. Possibly that is not there, my lord. Premeditation to kill, my lord.
You see, out here in your evidence, you have said that their father brought the axe. You, during the tussle, it fell and you threw away the axe. In your 164 statement, you say that while entering the house, I found an axe and in a fit of anger, I struck my father on his head with the axe.
Well, 164 later resided, my lord, in 313. During 313 later resided, my lord. This is pointing out. When a retracted conviction, my lord, conviction can be sustained, my lord.
You see, you were also confronted and you have said, it is not a fact that I have falsely stated that a scuffle ensued between us, that the chakwa got broken and both of us fell on the road, that my father released the axe from his grip and I threw away the axe. And of
My
course,
lord.
does not mention the confession statement.
164 was not confronted in my deposition.
Huh?
My
Not confronted, but there was
This version is different, my
there
lord.
a suggestion made to you,
Version is completely
and
different.
which is entirely so you are so according to you, your confession statement is not admissible because it is false.
No, that is on my
That which is false. Your evidence is false or this one is false? Which one is false?
164.
164, you said that you hit your father with an axe. In your evidence in the trial court,
My lord.
you said that you threw away the axe. There's nothing to show that you hit your father with an axe. So which is the correct version according to you?
My lord, my humble submission is that 164 is not substantive piece of evidence, my lord.
Not substantive piece of evidence.
However, my lord, what I feel, my lord,
If it
that
is supposing it is exhibited,
it is
let us-
exhibited, magistrate has
let
come, my
us
lord.
see, magistrate, what did she say?
But I'm only, my lord, 1 second, may I please, my lord.
No, no.
I only
definitely.
feel that, my lord, what has here stated in 164, my lord, possibly there, my lord. In defense, he has changed the version, my lord. But in both the versions, my lord, that premeditation to kill, my lord, and that is not there, my lord, and the grievance and provocation is possibly made of, my lord. That is my argument, my lord, before your lordships, my lord. In both the versions, my lord. That is my, because, my lord, he did not go there to kill his father, my lord. In both the versions, my lord. Humbly, my submission is that, my lord.
So what is the value of a confessional statement according to you? As per the law?
My lord,
Can it be used as evidence against you?
my lord.
Huh?
Yes, my lord.
And
It
if
is,
it can be used
lordship-
as evidence against you, is
Yes,
it a substantive piece of evidence? Yes, madam.
Lordship, if the guidelines, whatever is given by the this Guwahati High Court, if it's followed, your lordship, then it can be
Yes, ma'am.
sole basis of conviction.
But he has later on retracted the 164. My
All
Yes.
stipulation have been followed.
lord, I'm not saying that he should be.
Whether he has taken that plea that it has caused prejudice to him, your lordship. Later on, he cannot take the plea.
You retracted your statement.
No, he did
When,
not.
where have you retracted your statement? Huh?
313.
No, he didn't.
313, how can you
He said
retract at
yes.
313? 313 is not the stage for retracting.
Page 42, it can be, my lord.
Can be, show me the law.
I did not bring that, my lord, but
You did not bring that. huh?
page 42, it is a fact that I surrendered at PS, but I never made any confession.
Oh, but you never made it. That is the different. Your denial is different.
Page
Page 42.
Denial is different.
Well, I'm not saying that I should be acquitted because it's a retracted for confession. my lord. I'm saying even if it is.
Yes.
Where?
Page 42, question
For
18.
the statement exhibit 5 only. So yes, he said yes.
Page 42.
Page 41. Question number 16.
He said yes. No. Lordship, question number
And thereafter
16.
he recorded your confession, confess, have you, yes.
Yes.
Yeah, where is the retraction?
Yes.
Both are there, my lord. I'm trying to
What?
only point out.
Huh?
Both is there, my lord.
Huh?
Next page again, he
Next
said,
page.
but I never made any confession. So the legal help, what was there, I do not.
Is a answer given by an accused under 313? Is it a piece of evidence? Can it be used? It can only be
In that
used for
scenario-
explaining something.
In that
That's
scenario,
all.
106, everything that is there, but here, no. I'm only pointing, but my humble submission is that there is no premeditation, and the grave and sudden provocation is possibly there. That to kill his father, that is possibly not there. Possibly, he never imagined that day he would be killed. That occurrence would take place. He had never imagined. What I feel from reading the record,
Yes, it appears that yes, that day, because that was the second time you saw each other also.
My lord.
You didn't plan to kill, but you killed. And whether it was due to grave and sudden provocation. we'll have
May
to
I
see.
please, my lord, lordship allows me.
Yes.
Subsequently, he stated that I never made any confession. In Question number 18. Mhm.
Yes.
My lord, this is Deepan Soikia, my lord.
Yeah.
2013 to GLR 241.
2013 to GLR. Yes.
The para 22 much.
Para 22. Yes.
We have before us a village simpleton who apparently is not educated and belongs to a scheduled caste community. He seems to have been blinded by rage against his father for the mistreatment of his mother. He was not able to tolerate any further the constant harassment of his mother by his father. Out of sheer anger, he strangulated his father. He said in his statement before the court made under section 313 that, and then out of anger, I choked him and inflicted several dow blows on his back. Down below, my lord. Further, no cogent evidences are present to indicate intention of premeditation to kill his father, so as to attract provisions of section 302 of the IPC. The appellant was blinded by anger provoked by the maltreatment of his mother by his father, and he assaulted his father by choking and injuring him and ran away from the scene of the crime without trying to find out whether his father was dead or not, thus showing lack of intention to kill his father. In the bottom, my lord, towards the bottom, my lord.
Yes.
It is also to be noted that in his confession statement made under section 164 CRPC, which he reiterated in a statement made before the court on the 313, he never stated that he wanted to kill his father. All he stated was that he was very angry with his father for the harassment and ill treatment of his mother by his father. The fact that he was remorseful for his act and repented for his act while making confessional statement is also indicative of lack of any willful intention or premeditated plan to kill his father. We are also aware that the appellant has been truthful, honest, and forthcoming in owning up to the act. Did not make any attempt to mislead or hide any crucial fact. It may be noted that the appellant insisted on confessing his crime in spite of being warned by the magistrate. What we find is that the appellant has lost his power of self-control because of the continued harassment of his mother by his father, and out of uncontrollable anger, he assaulted his father, which ultimately led to the death of his father. This is 1 minute. Then another 1 minute. In that case, my lord, it was a knife dagger blows, man. In that case, my lord. In this is one of Manju Lakra, 2013 6 GLR 222.
Para.
Para 30, my lord.
30.
30.
Yes.
May I read, my lord? The accused appellant has, however, clearly stated in her confession that she killed her husband out of anger because her husband had been committing atrocity on her, and he used to come at night in drunken state, and on the night of the occurrence too, he came drunk and beat her and she sustained injuries, which had in fact been noticed as already pointed out above, even by the judicial magistrate who had recorded the confession. What emerges is that it's true and voluntary. And then Malad Para 116, Malad, last page. Malad. Why I was saying my increases, Malad. Para 116, Malad. Lordship is found, Malad. To put it a little differently, the conduct of the accused appellant's husband had been building up inside the accused appellant strong resentment and rage. Though she had been controlling and suppressing the rage and the resentment which had been building up inside her, her rage and resentment were waiting to erupt at any further violent conduct of her husband. The accused appellant had been thus sitting on a volcano of rage, resentment and rage, which had been continuously building up and boiling inside, waiting to burst open. Even a small flicker of any further intolerable behavior of her husband could have made the volcano erupt. And that is precisely what happened on the fateful evening, when her husband, having come home in drunken state, as usually he did, started beating her up. The provocation which the conduct of the accused appellant's husband so provided to the accused appellant was not only grave, but can be perceived as sudden too, inasmuch as the night might have passed without her husband having beaten her up. And in that event, nothing further would have happened. But when her husband took, as usually he did, recourse to beating her up, she, having lost the power of self-control, reacted by snatching away the lathi from the hands of her husband and started beating him up without realizing that he was likely to die. No wonder, therefore, that she hit her husband even on his legs, apart from, of course, head and back of his neck. What, however, proved fatal was the beating by the accused appellant of her husband on the latter's chest and abdominal area. One more only.
How many have you got?
This last one. This again our High Court murder. 2018 SCC online GAU 585 minute. Ranjit Tanti. This also axe blow murder. Para 9. In the case of Muthu versus State reported in so and so, it has been held that when in the heat of moment or in a fit of anger a person does an act without premeditation, that person must also be punished, but his punishment should be lesser than that of premeditated offenses. The Supreme Court has observed that it is for this reason that exceptions 1 and 4 have been inserted in section 300 of the Penal Code. Exception 4 to section 300 Penal Code clearly provides that culpable homicide is not murder if it is committed without premeditation in a sudden fright, in the heat of passion upon a sudden quarrel, without the offender having taken undue advantage or acted in a cruel or unusual manner. Here also, my lord, axe blow, my lord, and 3 injuries. This is, my lord, I think father killing brother or something. Same family. So that is my submission.
Yes.
Lordship, in the case, Lordship, there are confessional statement, judicial confession made by the accused person. Vis-a-vis, there are eyewitnesses to the occurrence. And apart from that, there are extrajudicial confession made to your Lordship, 2 persons. That is before PW8 and PW9. PW8 and PW5, my lord.
Extrajudicial confessions too?
Before PW5 as well as PW8 by the accused person.
Eyewitness, how many? 1.
Only 1, PW2.
So your case is one judicial confession,
Yes,
one extra
two
judicial
extrajudicial confessions before.
and one
PW
eyewitness.
Yes. And all the formalities have been followed by the magistrate concerned, my lord, while recording the confessional statement. Adequate time has been given to him. He has given the time to reflection, my lord. It was stated to him whether that it may use against him if he made the confessional statement, that all the formalities have been fulfilled. Although the petitioner has retracted in the later stage while recording 313, that is not sufficient. I have got a judgment, my lord. Although he's retracted at the later stage, but he had not made the confession. On the other hand, in 313, while answering one of the questions, he said that he made the confession, my lord. So your lordship, if your lordship takes into account these factors, learned court below has rightly convicted the accused person, my lord. Lordship, may I take your lordship to the evidence of PW2 first, who happens to be the second wife of the deceased, my lord. PW2 Monju Bora. This is Biren Bora, page 12. This is Biren Bora was my husband. I am the second wife of my husband. His first wife is still alive. Accused Ramesh Bora is the son of my husband from his first wife. This is Biren Bora used to live separately along with me, while accused used to live separately along with his mother. The incident took place in the month of Bohag this year. Around 7:30 p.m. one day in the month of Bohag, my husband was returning home after herding the cattle, and no sooner had he reached the gateway, the accused hacked him thrice on his neck. Your lordship will kindly note this part. Lordship had the deceased thrice on his neck. The intention to kill is there. It's not that once he was hacked, it was for the third time he was hacked, my lord. He also hacked him on his belly. At the time of the incident, I was at the frontal part of the house and I witnessed the incident. The accused came straight and hacked him. Thereafter, the accused brought my husband to the courtyard by holding him and laid him there. I do not know why he had assaulted him. I immediately went to the house of BDP secretary and informed him of the incident. I do not know his name, but he is addressed as Baba. The BDP secretary came there. Thereafter, the BDP secretary informed the police station of it. Whereupon police arrived there, I got an Ezahar written by Baba and lodged it with the police station. I put my thumb impression on the Ezahar. The accused fled from the place of occurrence. I do not know where he had gone. It was not completely dark at the time of occurrence and there was enough light to recognize a person. Hence, I could witness the incident. I got married to Biren Bora about 12 years ago from today. Prior to my marriage with Biren Bora, the accused and his younger brother had been living with their mother. But the accused younger brother had committed suicide prior to my marriage itself. The accused and his mother stay in a separate house. It is not a fact that in course of my statement before the police, I did not state that the accused had hacked thrice and that he had hacked on the belly too. It is not a fact that the accused did not run away after the incident. My husband was a retired army personnel. He received pension. The accused was given the share of landed property, but he was not given the full share he is entitled to. There was no provision for light at the place of occurrence. There was no provision of light. It is not a fact that I did not witness the incident. It is not a fact that it was dark. It is not a fact that the accused did not hack my husband thrice on his neck and that I have adduced false evidence. It is not a fact that I have adduced false evidence. So, your lordship, her statement in chief could not be broken, my lord. Now I take your lordship.
Before the IO, the IO says that she did not state before the IO that she saw the hitting on the neck by 3 times before the IO.
Then extrajudicial confession part before PW 5, my lord.
PW number
5.
Yes.
Page 18. One evening about 3 months ago, the incident took place in front of the deceased Biren Bora's house. At that time, I was at home. Since I am the VDP secretary of village Ratanpur, Biren Bora's second wife approached me and informed me that a fight had started between the accused and Biren Bora. Since she could not dissuade them from fighting, She had come to me and informed me about it. Then I came to the place of occurrence, saw the accused splashing water on the road with a bucket. The road is adjacent to Biren Bora's courtyard. On being asked, the accused replied to me that he had a fight with his father. When I asked him where that person was, he replied that he had pulled him to the courtyard and left him there. Then I saw that person lying on the courtyard. Thereafter, I informed the police, so and so. Lordship, that fighting part is there, your Lordship. Fighting part by the extrajudicial confession regarding fighting is there. Then later the police arrived there. When I had a look on Biren Bora, I found him dead. After the arrival of police, I noticed some 4 marks on the neck of Biren Bora. Police recovered an axe from the place of occurrence and seized. Exhibit 2 is the scissor list, wherein Exhibit 2 is my signature. Material Exhibit 1 is the seized axe, and so is the signature. The police got my statement recorded in the court. Exhibit 4 is my statement. Exhibit so and so is my signature. I do not know over what
No, you
method
said
of work.
the
No,
fact-
that killing part, that's not there,
That is
but
not-
fighting part is there, your Lordship. May I read the cross part? The axe was not lying near the dead body. A constable searched it out. I do not know where it was lying. Manju Bora did not come to the place of occurrence after informing me about the incident. She arrived at the place of occurrence some 10-15 minutes after we had reached there. Manju Bora told me about the quarrel that took place between the father and the son. It is not a fact that I have falsely deposed that the accused is splashing water on the road. It is not a fact that the accused did not tell me that he had assaulted his father. Lordship, that part is there. It is not a fact that the accused did not tell me that he had assaulted his father and left him on the courtyard. It is not a fact that I have produced false evidence in the courtyard. Then the evidence of PW 8, my lord.
Yes.
Lordship, page 24, para 2. The incident took place in the evening hours, 28 days of April, in the house of deceased Biren Bora. I do not stay in that house, but I stay in a separate house, a little distance away from that house. Biren Bora used to stay with his second wife. This PW8 is the first wife of the deceased and mother of the accused, my lord. At the time of the incident, I was at home. In the evening, when I went to teach her the cattle and the goats, I saw Biren Bora lying a little distance away from the house. Thereafter, I heard a commotion. Then Diganta Bora, the nephew of Biren Bora, came out and told me that he had seen injury on the person of Biren Bora. Then I went near the dead body. Going there, I became speechless. After a while, I could learn that my husband Biren Bora had died. Then I returned to my house and met my son there. Your Lordship will kindly note that part. He told me that Biren Bora had rushed at him and assaulted him, and that he had assaulted Biren Bora with an axe just to save himself. The axe does not belong to my house. I am not aware if it belonged to Biren Bora. That assault part is there, your Lordship. That he had assault, as a result of which the victim died, my lord.
That is not disputed.
Yes, yes, my lord.
That is not
And
disputed.
confession statement, your Lordship will kindly have a look.
What he's trying to say
Yes,
is that there was no premeditation or
Meditation?
intention on the part of
Yes.
him to kill the father.
father.
However, due to a quarrel that ensued and due to the assault being made by the father on him, he reacted.
Yes.
So there was a fight between them.
Fight between them.
And in the fight
Let
this
us see what he stated in his confessional statement before the magistrate, my lord. Page 80.
Page 80.
Yes,
86.
80, your
86
lordship.
is the operative part. 80 it starts.
86 is the operative part.
Yes.
Yes. Earlier, my father's, prior to that, your lordship, all the questions, needed questions are asked to him, your lordship. Formally, all the formalities have been followed, your lordship. Earlier, my father served in the Indian Army, and after his retirement in 1997, he returned home. My younger brother, mother, and I lived in our house. After consuming liquor, my father used to beat my younger brother, mother, and me. My father drove my younger brother and mother out of the house some 7 years ago from today, and for that reason, my younger brother went to my maternal uncle's house and committed suicide there. Without bringing my mother back to the house. My father married another woman and brought her home about 6 years ago. Later, as my
Let
mother,
him be, yeah. Yes, where are we?
later, as my mother lost the case against my father, the latter gave 1 bigha land to the former near his house to construct a house thereon.
Where is this?
Lordships about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10th line, page 86.
Confession.
Confessional statement.
So land was given.
Yes, my mother and I, Lordship has got it, my lord.
Yeah.
My mother and I constructed a house on that plot of land and lived there. My father did not give any share of his pension amount to my mother. My father did not give us any cultivable land. Later, I went to Hyderabad to work there. I returned home from Hyderabad to enjoy Rongali Bihu. One day, I approached my father seeking landed property from him, but he did not give me any landed property. On Tuesday last, my father came after consuming liquor and hurled abuses at me. He also told me that he would not give me any landed property. Then I asked my father not to abuse me, and I also told him that I would go to Hyderabad again. My father did not accept me as his son, and he scolded my mother using very filthy words. My father asked me why I had not married yet. He also told me that I had illicit affair with my mother. Then, as it enraged me, I went near my father. When my father punched me and made attempt to assault me with a fence post. Fearing that my father would assault me, I went inside the house. While entering the house, I found an axe on the door, and in a fit of anger, I struck my father on his head with that axe. Then my father fell down. When I went,
Just a minute. Then my father punched me and made an attempt to assault me with. Fearing that my father would assault me, I went inside. Yes. Okay.
fearing that my father would assault me, I went inside the house. While entering the house, I found an axe on the door, and in a fit of anger, I struck my father on his head with that axe. Then my father fell down. When I went towards the road, my father attempted to assault me with stones. Then I dealt an axe blow to my father again. Thereafter, I left that place. Later, I came to know that my father had died. Thereafter, I appeared so and so. So, your lordship, it's not that anger part was there. It's not that at the heat of moment it was done. He had like inside his mind there was like not good feeling against for his father, your lordship, because he did not. The victim did not give them landed property or the shares whatever they wanted, my lord. And off and on he used to abuse the victim, that accused person, your lordship. So it's not that there was a heat of like it was not a sudden fight. Intention part was there to kill the deceased, my lord. Otherwise, why would have he assaulted
No,
one or
164 says, page 87.
yes,
It says, fearing that my father would assault me, I went inside the house. Full
yes,
stop. While entering the house, I found an axe on the door, and in a fit of anger,
Yes.
I struck my father on his head with that axe.
yes. Then
So
my
it was
father
a-
fell
it-
down.
it-
There
it-
one more part, my lord.
Ah,
Then my father fell down. When I went towards the road, my father attempted to assault me with stones. Then I dealt an axe blow to my father again. It's not that single blow was given. It was again and again. It was on the belly. It was on the chest, right?
So he got angry again.
Yes. It was not a, like due to sudden provocation or sudden anger. It was continuous, your lordship. He had like enmity or whatever against his father, your lordship. No good feeling against for. It's not on the spur of the moment. So intention part was there. Even if your lordship tries to bring it, as my learned friends pointed out, to bring the case under the provision of 304, the general exception, the exception part, it would be 304 part 1, my intention part is there, your lordship, intention and knowledge. And confession, it was like all stipulation had been followed. That is enough to convict the accused person.
Anything else?
Either on 302 or under 304 part 1, that your lordship will decide. If your lordship brings into the provocation part, heat of passion, then your lordship, but the intention was there, It's on the vital part of the body. It is not only once he was like, he was assaulted, it was repeated assault was given. So your lordship, intention and knowledge, if it's coupled into it, will come under 304 part 1 general. That 304 part 1, your lordship. If your lordship comes into under the general exception. Lordship, may I, one more submission may I make? Lordship, it was on the, it was in the courtyard, it was just front door of the occurrence that taken place.
It was on the road,
It was on the road, but it's like, as PW2 has said,
in front of the.
yes,
land
out of the PW2, the deceased. It's not that the victim went to him and assaulted.
It was not on the, he had to go to the house.
Yes,
Get
and
the
came
axe,
back.
then come back.
Yes.
And then assault.
Yes, the timing part is not, the Supreme Court has said if time period is long, then that benefit would not come. But if it is within the, like the limited period, then the benefit may be given spur of the moment.
Time period long, my lord. Ran and came, my lord, not time period long. my lord.
That's what I am submitting in favor of you.
Are you submitting in his favor?
Not
I
like
doubt.
whatever is on record, I have to submit, my lord. My duty is
No,
not
no,
to object all the
okay,
time.
okay. I thought you were objecting.
No, I am objecting that part, your lordship, that's it's on the front side of the house of the PW2. Lordship, it's not that at the residence of the accused person it has taken place.
Yes, it's not in
My
the
lord.
residence of the accused person.
Yes. One of the judgments I have got which goes against him, 302.
Let us see.
2000, I'll read out slowly, your lordship, later and I'll give the citation.
Yes,
2010 9 SCC 799.
yes.
Singapagu Anjal, lordship, para 15 to 20. May I read out?
15 to?
15 to 20. May I read out, my lord?
Yes.
In the opinion, as nobody can enter into the mind of the accused, his intention has to be gathered from the weapon used, the part of the body chosen for the assault, and the nature of the injuries caused. Here, the appellant had chosen a crowbar as the weapon of offense. He has further chosen a vital part of the body. Here, the axe has been used, my lord. He could have used another, like other object also. He used axe, my lord. Here, the appellant had chosen a crowbar as a weapon of offense. His father chosen a vital part of the body, the head for causing the injury which had caused multiple fracture of skull. This clearly shows the force with which the appellant had used the weapon. The cumulative effect of all these factors irresistibly leads to one and the only conclusion that the appellant intended to cause death of the deceased. Now, referring to decisions of this court in Gurmail Singh, the same is clearly distinguishable. In the said case, on facts, it was found that the accused did not intend to cause the injury, which in fact was to have been caused, and in the said background, it is held that the accused did not intend to cause the death, which is not the situation here. In Jagtar Singh, the incident was preceded by a sudden and chance quarrel. And in that background, the court held that allegation proved to be under section 304 part 2. In Gurmukh Singh, the injury found on the deceased was only depression of skull bone, and the occurrence had taken place on the spur of moment. In the background of the aforesaid facts, infliction of a single lathi blow was not found enough to infer the intention of the accused to cause death of the accused. Here, as pointed out above, the three important factors enumerated above clearly lead to the conclusion that the appellant intended to cause death. Hence, all these decisions are clearly distinguishable. In the present case, as pointed out above, the weapon used, the part of the body chosen for the assault, and the intensity with which the appellant assaulted the deceased clearly go to show that he intended to cause the death of the deceased. So, in this case, the victim died instantaneously, Your Lordship, as a result of assault.
Anything?
Lordship, may I see if I get?
Oh,
any-
I thought you finished. How much more time will you take?
Regarding this part only, this will do, I
Okay.
think. And confession statement, if the stipulations have been followed, it will like, it can be given, it can be lordship.
So that is not the case that the
Yes,
stipulations
yes,
have
yeah,
not been
normally
followed.
followed. Lordship.
May I please, your lordship? Lordship, whatever evidence has come on record from the PW2, PW5, PW8, it appears that whatever my learned friend is trying to show, that there was some grave and sudden provocation, or there was some, if the provocation self-control, it must come from the deceased. That is, it must come from my father part, lordship, not from him, lordship. Sudden provocation, where from it has been gathered? From the evidence on record. If the confessional statement and the DW1 statement, that is the accused statement, are set separately. If we find what are the main evidences or the eyewitnesses, from there no positive evidence comes that I have started the quarrel, I have provoked him to do that act. Where that comes? Because in this case,
He says that, he
Yes,
says that you have charged him with
Yes,
having illicit relationship
Yes,
with your mother.
Yes, Lordship. Lordship, regarding that, I am coming, Lordship. If we see that from the positive evidence, that means, Lordship, the evidence of the prosecution witness or the defense witness, Lordship, that has not come on record that I have forced him to do that act. That provocation has come from my act. Because if we see whatever the statements, the accused is keep on changing. In one point of time, he is showing that he has not done any act, because he's stated, if we see the DW1, Lordship, he has stated that there was a dashing and pulling. Thereafter, I throw the axe. In next round, in his 164 statement, he states that father has come with the fence. Thereafter, I have done with the axe. Whether an accused may be allowed to keep on changing in statement, and confessional statement is not that the law permits that a person will come and he will confess and everything will gone, that he will take that I have done with a confession statement. If he comes that yes, I have committed, but due to this grave and sudden provocation or due to the sudden quarrel, can it be allowed, Lordship? Because positive evidence are those which comes from the mouth of the witnesses, Lordship, not from the mouth of the accused, Lordship. That cannot be allowed. Otherwise, Lordship, any one person will come and he will confess and he will put the thing that yes, I have done it. But due to the self-defense or due to some provocation from my father, can it be allowed, Lordship? Because whatever provocation, because the law says that whatever provocation or whatever is to come from the evidence on record, not from the evidence of the accused, Lordship. Statement of accused, confession letter is different, altogether different thing, Lordship. It should come from the mouth of the witnesses, Lordship. But if we gather all the evidences, whatever we have gathered, Lordship, there is not a single thing that yes, there was a fight, but whether I have provoked him because he is trying to bring it under the exception number 1, Lordship, then that provocation should come from the deceased, Lordship. That means from the father, not from the son, Lordship. Because no one has told that I have started the quarrel, or I means, Lordship, the deceased. I am indicating myself as the deceased, Lordship, because I am defending him. There is no to the effect, Lordship, that the quarrel I have started, because if the case is to be brought under the first exception, Lordship, culpable homicide is not murder if the offender will stay deprived of the power of self-control by grave and sudden provocation. But in this case, Lordship, that has not come up on evidence, Lordship. Only from the statement, once he is stating that relying upon the I have done it. If we see the defense witness, completely silent, Lordship. He is saving himself. He is stating that I have thrown away the X. Can that be allowed, Lordship? On the same person, one stand is different. Again, he comes with another stand in 313 statement. Yes, he has stated a yes. 313 statement. I have snatched the X from my father's hand. Can it be, Lordship? If that, then the accused will be the dictator of what his statement, Lordship. Can that be allowed, Lordship? If that, because the facts is to be gathered from whatever has come up on the evidence.
Accused has to be the dictator of what he says.
Lordship.
No one else can dictate for him.
No, Lordship, because
positive evidence also we
Whether
looked
the
up.
court believes him or not, that's a different
Yes,
issue.
Lordship, because I am stating banking because he is always changing his statements, Lordship. And if we see the 313 statement, again he comes with a different stand, Lordship. Is in one part he is resigning his statement. Again he is saying, yes, I've given my statement, well aware. Thereafter he is stating, yes, I have snatched the dove
That,
from the
that,
Lordship.
that reminds me of that joke. No? Why did the chicken cross the road?
Yes.
Why?
Lordship, I forgot.
To get to the other side.
Yes.
Now, why did it cross back?
Yes,
To be a double cross.
double cross.
Now, why did it cross back again? To
Triple
be a
crossing,
dirty double crosser.
Lordship.
So that is what they're trying to say in a way that
Yes,
he's been
yes.
changing his stance so many
Yes,
times.
Lordship. If that be, then every accused will come with a confessional statement and he will say, yes, I have done it in my self-defense or to save my family or to save my mother or to save the property, Lordship, whether that can be allowed. Because there is no positive evidence to that effect that yes, that I have started the fight. Because whatever exception is there, it has said that yes, I must I must be will state of the self-control. That means it has to come from the other end, Lordship. But in this case, there is nothing as such statement, Lordship. Only a fighting, whether it clears that I have started, who has started, there is nothing, Lordship. All of are saying, yes, there was a fight. But what was that fight? Whether I have started it or he has started it, completely silent, Lordship. Because if he has to grab the benefit of these exceptions, if he want that his case is to be converted under section 300, exceptions 304 part 1 or part 2, then why? When it will be converted? Only when it will come under the exception, Lordships. If he can't bring under his case under the exceptions, how can he get the benefit, Lordship? That is my humble submission. Because in this case, the prosecution has proved this case beyond doubt and he has failed that I have started. I have given him a provocation to do that. So his statement alone cannot be given him the benefit, Lordship. And that to keep on changing. In 3113 different statement, in Lordship 164 that is confessional statement, a different stand. And while giving his statement as DW1, a completely different stand, saving himself, Lordship, can that be allowed? If yes, then a different. If no, then Lordship, he has to be punished. And the conviction should not be interfered, Lordship. 300, he has to be convicted under 302 IPC, Lordship. That is my humble submission, Lordship.
Lordship, one of the factors that he had killed his own father, that the Lordship will keep it in mind. Patricide.
Own father.
Yes.
And 304, if 304 part 1 is given, then it might extend to 15 years, extended to life, right? 304 part.
You have killed your own father.
Yes.
May I rebut, Malik?
Not usually.
May I, Malik?
Yes. Yes. You finish?
Yes, Lordship, almost. If he says
Almost
something,
or?
no, Lordship, if he says some points, new points, then
some
I have
new
to
points.
reply.
Okay. Yes.
Well, coming to the positive evidence, my lord, here the prosecution evidence is binding on the prosecution, my lord.
Yes.
Principle is there, my lord. PW2 is consciously silent about the fact that the fight took place. PW5 says that she told me she could not break up the fight. She told me to come and break up the fight. She is not saying anything about the fight, my lord. How reliable is she? What she could decide that, my lord. Again, positive evidence, my lord. PW5 fight took place, my lord, from the mouth of the second one. PW8, my lord, she was not controverted or that made hostile or anything. Well, prosecution witness saying that fight took place, assaulted me, tried to assault my son. That is why he attacked. Has she been made hostile, my lord? Is that not binding upon the prosecution that on the face of the record that a fight took place, her son was assaulted, and during the assault he hit his father, my lord? That is positive evidence, my lord. And my lord, from the beginning only, I'm saying that yes, he has resigned from 164 in his deposition as a DW, my lord. But my argument was that, my lord, either version, my lord, there is no premeditation, my lord. He did not go there to kill his father, my lord. My humble submission cannot be, my lord.
No, that appears to be there.
My lord. And then, my lord, coming to my lord, why I'm saying it was grave and sudden, my lord, that Monju Lokda case, my lord. He had come home in a drunken state. Every night he comes home in a drunken state in that case, my lord. This Honorable High Court, my lord, had that night was the breaking point.
No, but remember, in that case, he used to beat her up.
Beat her up daily, my lord, daily.
So
In a drunken state.
this case is different.
Different, my
They are
lord.
living in different places.
I'm just trying to draw a parallel, my lord. I'm not saying similar, but just trying to draw a parallel, my lord. That boiling, that point, my lord, that point again and
That
again.
boiling point will be for that wife, not for the son. This son is in Hyderabad doing his job.
He was
He's
sent
not
to
being
Hyderabad
beaten,
after that suicide, my lord.
He is not being assaulted every day. Sorry.
And my
That,
lord,
that is a
that
different
Deepan
issue.
Soikia, my lord, also a case of that Deepan Soikia, my lord. Also a case of practicide, my lord. There was dagger blow, my lord, 4 dagger blows on the back, my lord. And there also, my lord, what my learned senior counsel for the prosecution said, my lord, even after putting all those questions in the
Senior counsel for the
prosecution, my lord.
Informing even I am appearing.
My lord,
Oh,
no,
no.
no. Senior counsel for
Oh,
prosecution.
okay.
My lord, senior counsel prosecution, my lord.
This is for prosecution.
Prosecution, my lord. She has said that, my lord, all those questions were put and he still confessed, my lord. There, my lord, Deepan Soikia, I would rely upon a line, my lord.
Anyway, see, I think we have heard enough.
We are also aware that the appellant has
What
been
more? You will not end.
truthful, honest, and forthcoming, my lord. Truthful, honest, and forthcoming in owning up to the act and did not make any attempt to mislead or hide any crucial fact. It may also be noted that the appellant insisted on confessing his crime in spite of being warned by the magistrate.
It's crucial to learn. A crucial point he has not taken.
Crucial, my lord.
No, one more factor, just in favor of you only. If 2 views are possible, my lord, so one view which goes in his favor should. One view is regarding fight which has taken place, grave and sudden provocation. Other view is that there was no provocation.
Okay. Heard, Mr.
N. Mahajan.
N. Mahajan.
Well,
Any relation to Mr. B.K. Mahajan?
Son.
N. Mahajan, Learned, what? Counsel or amicus or what?
counsel, my counsel.
Learned counsel for the appellant. Also heard Miss B. Buyan, additional PP for the state, and Mr.
You should be legal aid counsel.
Legal
Legal aid counsel.
Legal aid counsel for the informant.
Yes, sir.
Bracket is point number 2.
Yes, sir.
Just say hearing concluded, judgment reserved. Huh? Then at the bottom you write. Same, this parties will be same. Then you write. The challenge in this appeal is to the impugned judgment and order dated 5/10/2016 passed by the learned session judge, Golaghat, in sessions case number 76/2015, by which the appellant has been convicted under section 302 IPC and sentenced to undergo life imprisonment with and sentenced to undergo rigorous imprisonment for life with a fine of rupees 5,000, in default, simple imprisonment for 1 month. The prosecution case in brief is that an FIR was lodged on (29/4/2015) by PW number 1, who is the second wife, or PW number 2, Is it?
2 months.
Affidavit number 2. By the second wife of the deceased, Biren Bora. To the effect that the appellant had killed the deceased around 8 p.m. on 28/4/2015. Full stop. In pursuance to the FIR for Pathar PS case number 43/15 under section 302 IPC was registered. Full stop. After investigation of the case, the IO having found a prima facie case under section 302 against the appellant, filed the charge sheet. First stop, next paragraph. Charge under section 302 IPC was framed against the appellant on 2/7/2015, to which the appellant pleaded guilty. Full stop. Thereafter, ten prosecution witnesses and 2 defense witnesses were examined by the learned trial court. Full stop. Examination of the appellant was done under section 313 CRPC. And thereafter, the appellant was convicted and sentenced in terms of the impugned judgment and order dated 5/10/2016, passed in Sessions case number 76/2015. Acha, one more thing you write. After investigation was done, no, I said somewhere, no? Investigation was done and the confessional statement of the appellant was taken under section 164 CRPC. And then you read it. Next paragraph. The learned counsel for the appellant submits at the outset that there is no denial with the fact that the cause of death of the deceased was due to the action of the appellant. Correct? Why? How did he die?
As per medical, my lord, because of the neck blow.
As per your submission, how did he die?
From the medical, my lord, neck
As
blow.
per due to the action of the appellant, which is recorded in the evidence given by Dr. Rajiv Kumar Prasad, bracket PW number 1.
1.
PW-1. Huh? That's it.
Action of the appellant will happen.
Huh? Action of the appellant. That was. I did not. So you did not cause the death. You did not cause the death. You have to be sure. You cannot have a cake and eat it too.
No.
You cannot say that I did not cause the death, but I want exception to 300 to be
Yes.
applicable to me.
Oh.
You have got to take a stand.
You know, previous other television posts are the one that had assaulted, right?
You have got to take a stand. What is it? Huh?
Myself.
Yes, madam, which para?
There are 15 to 20. You have
Okay, that's
Lordship
para
noted
15 to
down.
20. Okay.
Already noted it by your
Huh,
Lordship.
Next. The next para, the counsel for the appellant submits that as his father, bracket deceased, had abused him and scolded his mother by using filthy words. Besides, alleging that the appellant had been having an illicit affair with his mother, comma, that is PW number 8, comma. An argument started. Full stop. Thereafter, as the deceased had punched the appellant and made an attempt to assault him with a fence post, comma. The appellant had struck him with an axe, correct? Or you're denying that?
Well, I got confused. I beg my Lord's pardon.
Huh?
That time I got confused. I beg my Lord's pardon.
Huh?
That time I got confused. I could not understand. I beg my Lord's pardon.
So you struck him with an axe.
Well,
We have got to record exactly what he says. Because we don't want him to change his stand later on.
no.
So what we are stating now
Well,
is in direct contradiction to what you stated in your evidence.
I beg my Lord's pardon. I got
Huh?
confused. I beg my Lord's pardon. My Lord. I got confused.
Confused.
My Lord. I beg my Lord's pardon.
So your evidence to that aspect is wrong.
No, my Lord.
Hmm?
I got confused at that point. My Lord. Sorry, I beg my Lord's pardon.
So you struck him with an axe.
My Lord.
Good stuff. The next paragraph, the appearance counsel submits that there was no premeditation involved in the action of the appellant, and the same had occurred due to grave and sudden provocation. Full stop. There was no intention to kill the deceased, and it was only due to the argument that had suddenly flared up between the appellant and the deceased, that the deceased was struck by an axe by the appellant. Full stop. He submits that the evidence of the prosecution number 2 and 5. No, the evidence of the evidence of PW number 5. who has only conveyed the communication made by PW number 2 to PW number 5 shows that a quarrel had taken place between the appellant and the deceased. The learned counsel for the appellant thus prays that as the incident would come within the ambit of exception 1 or 4 of section 300 IPC, comma, the appellant should have been convicted and sentenced under part 2 of section 304 IPC. That's your case. Anything have I missed out?
No, my lord.
In support of his submission, the learned counsel for the appellant has relied upon the judgments of this court in the case of so and so reported in 2013, 2 GLR 241, comma, then number 2, so and so, comma, 2013, 6 GLR 222, and number 3, dash versus dash, reported in 2018, FCC online, GAU 585. Full stop. That's all.
Well,
Full stop. Next para. Ms. B. Bhuyan, the additional PP, on the other hand, submits that there is no infirmity with the decision, with the impugned judgment and order, as the appellant has in his confessional statement under section 164 CRPC clearly admitted to the fact that the deceased had died in his hands. First of further, the appellant's extrajudicial confession, which is reflected in the evidence of PW5 and PW8, clearly goes to show that the appellant is guilty of the offense under section 302 IPC. Full stop. She further submits that PW number 2, who is the wife of who is the second wife, who is the second and present wife of the deceased, was an eyewitness to the crime. Full stop. She also submits that though the appellant is trying to out under section 300 IPC, has The appellant had the intention to kill the deceased, keeping in view the weapon of offense and the fact that he had struck vital parts of the body of the appellant, that is the neck and neck and
Belly, and more than
belly.
once, my lord, more
Neck
than
and
once.
belly.
There are
Around
three number of injuries.
neck and belly around 4 times. 4 or 5 times. More than once. Is it?
Three injuries.
Huh? No,
Three injuries.
neck was 3 times. Belly was 1. Is it?
Yes, injury was there.
No, but
Injuries
the
in the belly
dog,
and
huh? Just say
Postmortem
more than
report,
once.
366.
More than 3 times. Just say more than 3 times.
And since the relationship was not good, so then he had the intention to kill.
She also submits that the deceased. No, she also submits that the appellant was living with. No, was the son of the deceased and PW number 8, who is the first wife of the deceased Biren Bora. As relations between the appellant and appellant and PW number 8 on the one hand, and the appellant and the deceased on the other hand, were not good, What? So what does it show? Not good, so?
Lordship, he had the intention to
There was an
cause
intention
harm to
to-
the deceased.
There was an intention to cause harm to the
Yes.
deceased. She just submits that, no, first up. In respect of the stand taken by the learned additional PP, that the intention of the appellant to kill the deceased could be gathered from the weapon used and the part of the body chosen for assault, she has relied upon the decision of the apex court in Dash versus Dash, reported in 2010 9 SCC 799. Do I give an alternative argument? Is it required? No.
Yes, even if your lordship taking into
Then you
account.
write
Yes.
next para. The learned additional PP submits in the alternative that if this court finds that the applicant's case, appellant's case, comes within the ambit of the exceptions carved out under section 300 IPC, the intention to kill being
Intention and
present,
knowledge, my lord.
the intention and knowledge to kill being present in the action of the appellant, the appellant would have to be convicted and sentenced under section 30 under the first part
Yes.
of section 304 IPC. That's all. Full stop. Next, Mr. U Chaudhary, learned counsel for the informant / respondent number 2, submits that a perusal of the confessional statement of the appellant under 164 CRPC, section 164 CRPC. And his evidence shows the changing stance taken by the appellant. The fact that the appellant has also changed his stand with regard to his confession under section 164 CRPC during his examination under 313, section 313 CRPC also goes to show that the reason given by the appellant for attracting the exceptions to 300 IPC cannot be considered. Comma, as he is a unreliable witness. The evidence given by the appellant vis-a-vis the statements made by him under section 164 CRPC are not in conformity, are contradictory, and as such, and contradictory. Full stop. He also submits that for the appellant to take the benefit of the exceptions to section 300 IPC, comma, the appellant would have to show that the quarrel, the alleged quarrel between the appellant and the deceased was started by the deceased. Full stop. However, the evidence recorded by the learned trial court does not give any indication as to who had started the quarrel between the appellant and the deceased. Full stop. He accordingly submits that as the appellant has killed his own father and as there is a constant change in the appellant statements vis-a-vis his evidence and statement under section 164 CRPC, the benefit of the exceptions under section 300 IPC is not attracted to this case.
One more point, Lordship.
And further, one more point, Lordship, that he has acted in an unusual manner and he has acted in a cruel.
Huh?
Lordship, and furthermore, why it should not be taken under the exceptions? Because fourth exceptions, if we come, the without premeditation is a sudden fight in a heat of passion upon a sudden call and provided without the offender having taken undue advantage or taken in a cruel or unusual manner. In this case, he has taken an undue advantage because one assault was sufficient. He has given thrice assault, and further, he has acted in an unusual and cruel manner. So also it should not come.
So he also submits that the action of the appellant was undertaken in
And the act was done taking undue advantage.
was done by taking undue advantage and acting in a
Cruel manner.
cruel manner. Okay, right. We have heard the learned counsels for the parties. The evidence of PW number one, comma, that is the doctor, shows that in the opinion of the doctor, the cause of death was due to shock and hemorrhage as a result of cut injury in the neck sustained by the deceased. The injuries also show that there were cuts, there were three cuts, no, two cuts in the neck. And one cut in the one deep cut in the chest. And that the injuries were caused by a heavy sharp cutting weapon. The extract of the injury in the post-mortem report of PW number one is reproduced below. No, in the post-mortem, as given in his evidence, is reproduced below. Page 8, in red, page 8 and 9. 8, 9, and 10, Then the evidence of PW number 2, who is the second and surviving wife of the deceased Biren Bora, is to the effect that while her husband was returning home after herding cattle at around 7:30 p.m. and had reached the gateway to their house, the appellant had hacked him thrice on his neck and once on his belly. PW number 2 then went to the house of the VDP secretary and informed him of the incident. Next paragraph. The evidence of PW number 3, who is the nephew of the deceased Biren Bora, is that while he was in his house, he heard a commotion at the gateway of the deceased Biren Bora's house. When he came out, he found When he came out from his house, comma, he found the dead body of Biren Bora lying on the gateway. At this stage, this further, as it was a dark night, he did not go there. At this stage, PW number 3 was declared a hostile witness by the PP. In his cross-examination, PW number 3 states this is he denies. Page 14. This is the bottom part, he denies it. Police examined me. I did not say.
I did not state so.
Cross by prosecution or defense, that is not clear.
No, cross by defense decline, no? So it will be cross by prosecution.
He denies, my lord. Page
He denies
29
everything.
He denies page 29 in the IO says, he says.
No, page 15 is the page 14, 15.
He denies the.
He denies this.
In page 29, the IO says he made the statements.
He denies this, right? Okay, whatever I said. He denies the statement made by him to the police. Full stop. Next paragraph. PW4, who is the brother of the deceased Biren Bora, states in his evidence that he was told by PW number 8 that a quarrel had taken place between the appellant and the deceased. And that he was made a Caesar witness with regard to the acts that had been used for the crime. First time. PW4 also states in his evidence that PW number 2 had stated that the quarrel that a quarrel had taken place between the appellant and the deceased over the issue of pulling a cow, and that the appellant who was armed with an axe had come there and hacked the deceased. First one. PW number 4 also states that there had been regular quarrels between the appellant and the deceased. Next paragraph. the evidence of PW number 5, who is the VDP secretary of the village, is to the effect that PW number 2 had approached him and informed him that a fight had started between the appellant and the deceased. Since she could not stop them from fighting, she had come to inform him of the same. When he went to the place of occurrence, he saw the appellant splashing water on the road with a bucket. And on being asked, the appellant told him that he had a fight with his father. When asked by PW number 4, when the appellant was asked by PW number 5 as to where his father was, he was told that he had pulled the deceased to the courtyard, and left him there. In his cross-examination, PW number 5 states that PW number 2 had told him about the quarrel that took place between the father and the son. He also denied the suggestion that he had falsely deposed that the appellant was splashing water on the road. Splashing water on the road. Anyway, next. PW number 6 is the elder brother of the deceased Biren Bora. Who states that, who in his evidence states that he came to know from PW number 4 that the appellant had a quarrel with Biren Bora and that the appellant had killed him with an axe. In his cross-examination, PW number 6 stated that PW number 2 and the deceased Biren Bora were married 12 years ago, and that he had driven his first wife, PW number 8, from out of his house. Thereafter, another house was constructed for PW number 8. He also stated in this cross-examination that the deceased used to torture the appellant and his mother. Further, the deceased had alleged that the appellant had an illicit affair with his mother, bracket PW number 8. Full stop. The evidence of PW number 7 is to the effect that he was informed by the VDP secretary, PW number 5, that the deceased had been killed by his son, the appellant. He stood as a Caesar witness with regard to the seized acts. Yes, para. The evidence of PW number 8, who is the first wife of the deceased Biren Bora, is to the effect that the appellant, who was her son, told her that as the deceased had rushed at him with an intention to assault him, the appellant had assaulted the deceased with an axe to save himself. In her cross-examination, PW number 8 states that the deceased used to torture them and that he made a false allegation that she was having an illicit affair with her son, the appellant. In her cross-examination, PW number 8 also states that on the date of the incident, the deceased assaulted her when the appellant was not at home. When the appellant came home, PW number 8 informed him that the deceased had assaulted her, due to which the appellant went to his father to ask why he had assaulted PW number 8. Thereafter, the deceased assaulted the appellant and told him that he was having an illicit affair with PW number 8. As his son could not bear, as the appellant could not bear it, and as his father rushed at him, the appellant killed his father to save himself. Next. PW number 9 is the subdivisional judicial magistrate, Dhansiri Saru Pathar, who states that she had recorded the statement, the confession of the confessional statement of the appellant under section 164 CRPC. After giving him 24 hours time for reflection. After all the procedure was followed, comma, and the appellant was informed that he was not bound to make a confession which could be used against him and could be convicted on the basis of the same, comma. The appellant was the appellant made his confessional statement voluntary. The confessional statement of the appellant was exhibited as EXT-5 and the signature of the appellant was also identified. Next paragraph. PW number 10, who is the IO of the case, gave his evidence to the effect that after completing the investigation and following all the procedures, comma, besides seizing the weapon, charge sheet was submitted against the appellant under section 302 IPC. Yes, sir. Next para. The evidence of the appellant as DW-1 is to the effect that when he returned home in the evening on 28/4/2015, he found household articles broken and furniture lines scattered. First off, when he asked his mother who had done the said act, she remained silent. First off, however, a minor girl of the family told him that the deceased had assaulted his mother, bracket PW number 8. He then went to his father to ask him about it, comma, to which his father told him that you have never demanded any article or land till date. And now your mother has instigated you. Full stop. The deceased also told him that his mother was an evil woman and that why hadn't he got married yet. The deceased also stated to the appellant, inverted commas, have you kept your mother as your wife? Next para. The appellant, no, next para, continue. The appellant then hurled a chair, to which his father punched him in the face. Thereafter, a fight ensued, and his father beat him with a fence post. Thereafter, the appellant reached home And no sooner had he reached his gateway, then his father threw stones. The appellant hid himself behind a fence, and his father, armed with an axe, rushed at him with the intention to kill him. Thereafter, they got engaged in a tussle, during which his father released his grip on the axe. The appellant thereafter threw away the axe. His father thereafter became unconscious and fell on the road. He sprinkled water on him and took him inside. Thereafter, he left for his house. Completely false.
It didn't say.
They all completely. In his cross-examination, he denied the suggestions that the evidence given by him in his examination in chief was false. Next para, the evidence of DW number 2 is to the effect that on the day of the incident, the deceased had assaulted the appellant's mother by going after entering the house of PW number 8. Thereafter, appellant asked his father as to why he had assaulted his mother. Full stop. An altercation ensued, due to which the father died. In his cross-examination, DW number 2 says that he did not witness the incident. Gustav. That's all. Gustav. Next para. Okay, next para, you're right. The confessional statement made by the appellant under section 164 CRPC is reproduced here and below as follows. Page 86, from here to 87, 86, 87, okay. Anything else to be recorded?
That he being the son, kill his own father.
Huh?
That he is the son, who killed his father, your lordship, that fact that may be taken into account.
He killed his father. That much we know. We will.
Whole statement
Huh?
is not, whole statement is not. The specific one, that is section 3, where he said, yes.
313. 313. Then you write. Next para. The extract of the examination of the appellant under section 313 pertaining to question numbers. Where is that 313? 16,
Page 41.
Question number 60, question and answer number 16 and
And subsequently he denied.
and
Question number
18.
18.
Question and 16 and 18 are reproduced below, huh? Page 41 and page 42. No, we'll see.
Surrendered also. He surrendered after.
Yeah, how does it matter? He has to surrender. Everyone sees him. A small village, everyone knows everyone. Huh?
He surrendered.
Uh-huh.
Fled away from.
Is that relevant? He surrendered or did not surrender? Is it relevant?
He is a perpetrator of crime. He admits that. Like.
No, he's not denying that he did
Yes.
it. Anyway, we'll see now. So it's heavy.
Yes.
Huh? One item. Okay.
Obliged, my lord, highly obliged.
Yes. What is this?
This case, San's his mother, if I remember it.
Son?
Allegation is against me that I killed my mother. That is something different. Today, my lord, this hour, and my lord, honestly speaking, my lord, my humble submission, assistant jailer, my lord, called me up about the phone, and the accused person undergone a knee surgery and hip surgery both. Assistant jailer requested me to, if my IA is pending, unfortunately for suspension of the sentence. So, my lord, the matter may be taken up on Thursday, my lord.
No, this is any eyewitness.
Yes, yes. If I remember, I don't have the papers with me, but Lordship, I have read it earlier.
Only two eyewitness.
Eyewitnesses are there.
Two eyewitness, my lord, myself.
Father and his uncle, right?
Myself and PWD 7, my lord. They are eyewitness, my lord. And actually, my lord, only short, my lord, learned trial court below proceeded on the premises that how can a father accused or father is the informant, my lord, in this case. The learned trial court proceeded on the premises that how can a father inflict his own son in a case, my lord. So if I may, my lord, take the reverse turn, my lord, in other way, how can a son kill his own mother? If I turn the reverse otherwise, my lord. And my lord, there is a material contradiction that is there, my lord. Circumstantial evidence is somehow different, my lord. So that, my lord, on the next day, I will argue on that, my lord. Thursday, my lord, kindly, my lord. Thursday, kindly, my lord, since accused is suffering some surgery there. And there is a call from the assistant jail.
Murder case, what is the hurry?
My lord, this is allegation, my lord. I am accusing PWD 7. There is a quarrel between myself and with PWD 7, my lord, who happens to be maternal uncle. In between, my lord, PWD 7 hits my mother. That's the, my lord, my 313 statement also, I, my lord, clearly stated this much.
After the week, I think, because after next week.
Kindly, my lord, the date on then.
Right, due to paucity of time, matter is adjourned for a week.
Well, kindly date, my lord. Kindly, my lord.
They will fix this.
Next week, next, my lord, only a date, my lord. My humble submission, my lord.
They will come.
Next Wednesday, my lord.